Matter for admission, my lord. Notice has been ordered. I have taken the endorsement of the other side, my lord. In a final decree proceedings, in the midst of the proceedings, my lord, one of the sharer who had not been granted any share files an application. Based on that, my lord, the final decree court grants a share and passes a modifies the preliminary decree itself.
What have you filed?
I have filed an RFM against
No,
the.
what is this?
I am seeking for admission of the matter.
No, you should file an application. No? File an application.
My lord, pendency of the admission, my lord, the notice was ordered to the.
It's all right.
Early hearing.
It's a pending RFA.
My lord,
File an early hearing.
very well.
Better.
The only this one was, my lord, the commissioner warrant had been issued in the proceeding. That is the reason
Done
I
it earlier. When was it issued?
My lord, last week.
Could have filed an application. No, when is the date now?
My lord, the day after tomorrow, Friday is the day.
Just take it. Now, when do you want?
Tomorrow.
That's the whole difficulty, you know. Court doesn't really permit.
My lord. Obligation.
Get over the matter. So, is this? What is the position? What is the position at the board? Just
Yes.
ask him to stay. Just 1 minute. Just ask him to stay.
I have filed an application for modification of the interim order, Your Lordship.
Just 1 minute, please. Now, these final decree proceedings are day after tomorrow.
Yes.
Just give it. Tomorrow we can give. Yes.
Yes, my lord. Appellants want to withdraw the appeals. Posting for tomorrow.
Just give it, ma'am. They say he wants to. Is anyone appearing for the other side?
No, issues,
Fresh
notice,
matter.
yes,
Fresh?
yes, notice or not yet issued.
Yes. No, what is the urgency? What is the urgency? No, but this was partition suit, na? Final decree passed? Dismissed. Was there any stay before the trial court? Just give it, ma'am, what is convenient for us. Any convenient date. Yes,
My lord, fresh regular first appeal, my lords, of the year 24. Suit of.
is it a pending appeal?
No, my lord, fresh matter.
Huh.
Suit for partition. It was decreed, my lords. And subsequently, the appellant was unable to file the appeal well within time. Now, appeal is filed along with the condonation of.
What is the urgency?
Urgency is that, my lords, the respondents have already initiated the FTP proceedings. My lord. It's
Have
been
initiated, na?
Initiated, it's still pending, but the next
What is the date?
next date is not unknown, my lords. It's
Just
not
give-
informed.
We will give you in March.
Lords. At least post for a hearing on IA on delay, my lords.
We will look into it. Just give it in March or so, whatever is comfortable.
My lord, this is a writ petition, my lord's fresh matter.
Yes, one.
Please.
Give that.
6-3.
Just ask him objections removed. Objections removed.
All the objections are, and gave it in sort of.
Just take the date. Yes.
My lords, this is a service matter, my lords. An employee, my lords, his salary was cut. There was a committee formed. His salary was cut on an allegation that during the tender approval, there was some foul play. That was challenged before the CAT, my lords. CAT set aside the order and remanded the matter for fresh consideration. Order passed in 19/7/2023, my lords. The authorities have not taken any action. Neither have they complied with the order of the CAT, my lords.
But why are you here?
I filed for a direction, my lords, against the respondents.
Is the writ petition pending here?
No, my lords, this is a fresh writ petition seeking
Why
for.
have you filed a writ petition? You should go to file a contempt.
My lords, a contempt has also been filed, my lords.
Then
There has been, in fact, in the contempt, my lords, it's been pending for a year. There has been no action even there, my lords. They've only been seeking for an
so what have
adjournment,
you challenged? What is your prayer here?
for a direction, my lords, to comply with the comply with the order, my lords.
Maintainable? You have filed it there?
Please, my lord.
You will pursue there.
Lords, if the matter may be taken up, my lords, any date may be fixed.
You are saying something.
Please,
You have to pursue before the tribunal.
please.
What is the cause for you? You are a successful party before the tribunal,
Yes,
right?
yes, my lords, we
Pursue
have
that.
succeeded.
Pursue there. Ask him to pass an order and there would be an issue. If you have filed a contempt on a maintainability, there would be an issue. Whether writ petition would be maintainable. Getting?
Please.
Examine it. Go back.
Please, my.
Yes.
Last leave, my lord. From section 37, commercial appeal, my lord, have deposited 50%, my lord, about 5 crores before the commercial court. They have filed an application for withdrawal. And my lord, the matter listed before the commercial court on 15th. So it's well within the period of limitation. Objections are complied. It's a fresh matter.
No, you are the unsuccessful party.
Please, my lord.
In 34.
Please, my lord.
Okay. When
Have-
was that order passed?
It was 12th of December 2024, please, my lord.
And who had deposited the amount?
I have deposited, my lords.
So now what is the difficulty?
My lords, now, my lords, the claimant respondent has filed an application to withdraw that amount that I have deposited before the commercial court
Hmm.
when I was filing section 34, my lord. If, my lords, that application is allowed and if the money is, my lord,
When was the date list? When was the date given on 15th?
my lords, the memos of application have been filed recently, my lord.
No, when was that date given of 15th?
I plead ignorance of
No,
that.
before the trial court, you say it's a 15th date.
Please,
When
15
was that date given?
fixed, my lords, I'm not aware, my lord, because they moved the application recently, my lords. They have served a copy of the application on me and they have informed me that the date is fixed on
Who
15th.
is the other side?
But they're not on caveat, my lord. The respondent is not on caveat. They
Then
filed an application before the commercial court, my lord.
they have filed.
They have filed, my lord, and they have served a copy of that application that they have served.
And when was the 34 order passed?
12th of December, my lords, 2024, my lord.
Just take it, ma'am.
Obliged, my lord.
We'll give you date, just a moment, just wait.
Please,
15th now. What is 15th? 15th is Saturday. Hmm.
obliged, please.
Sir,
But you must,
Sir,
the objections removed?
Please,
Everything?
please, please, my lord.
Yes.
sir, sir,
My lord, fresh matter. My lord,
Yes.
fresh matter for admission, suit for possession filed by the respondent. Appellant is an agreement holder who is in part performance of the property under the agreement. When the suit for specific performance filed, the appellant was pending. Another suit for possession was filed and it came to be decreed. There was also a counterclaim filed by the appellant that also came to be dismissed. So 2 appeals are filed, my lord. Now the execution is already filed. Notice may probably will be dispensed.
Why?
That's the delay.
Because of the, you, within 2 years.
Within 2 years.
See it, they have not filed execution.
They
No?
have already filed execution, execution 85 of 20.
When was this decree passed?
My lord, decree was passed in November, my lord.
Why so late?
My lord, there were some negotiations happening and
We'll give you in March. Just give it in March. Yes.
my lord, may I kindly request for at least a date in the first week of March, my lord.
We'll give it.
4-3, sir.
Both are connected appeals?
Oh, connected, arising out of the same judgment.
Yes.
Is a pending matter, your lordship. And the respondent VDA has changed the nature of the property by constructing around my
What
property.
is this? This is an RFA,
This is a WP.
writ appeal.
Writ petition, your lordship.
No, writ petition is not here. Some other court. Yes, go ahead.
Your lordship, I have filed an application for modification of the interim order. The trial court has issued the attachment of mobile warrant. Now, I have sought for application to modify the interim order passed by this court. Lordship, my matter is very urgent.
See, what is the order passed?
Order passed it to deposit 75% of the decretal amount.
That's right.
That I have sought for modification because I am not entitled to pay the amount. Now, for extension of time also modification.
Have you filed any application for
Yes,
modification?
your lordship, I have filed application. In the trial court, it is on 15th.
What is the relevance of the trial court proceedings?
No, the executive, because of the stay, they are not
How much, when was the order passed? 75%?
17/1
17th of January.
January,
How much time was given?
4 weeks. So if it is expired on 15th, 16th, it will expire.
Just take it, ma'am. Just give it. You take a date, you say that you have filed an application for modification.
Tomorrow or day after tomorrow.
We will see it. We have to see this board also. Okay? You'll seek a date. Just give it convenient date.
5-3, sir.
5th of March. 5th of March, you can tell the executing court or the court below that you have filed an application. That's listed on 5th March. Okay?
Much obliged.
Yes. You have any mentioning?
It's appeal matter, my
Huh?
lord. I am for the respondents. Workman is out of
Complement,
employment for
Sharma.
almost 12 years, my lord.
Who is the appellant?
Narasimha Swami is the appellant, my lord.
Then you want a hearing for what?
Twice or thrice.
For the respondent?
I am for the respondent. my lord.
Just give it in mid-March, ma'am, somewhere, mid-March. Yes, which year? Ma'am, that's also checkup. Ma'am, checkup, writ appeal number. Huh. What is the, it's a pending matter, na? Why don't you file an early hearing? File an early hearing, not like this memo. Appropriate memo, serve the other side, early hearing. We will look into it. Yes. Pardon? Which matter? In this today's list, we'll come back. What about you,
My
ma'am?
lords, COMEP of 22, my lords, execution.
No, is it a pending matter or you want to mention it?
I want to mention it.
Yes, what is the matter?
It's 22, recovery of money, my lords.
Is it an RFA or a,
COMEP.
okay,
COMEP, execution proceedings have been filed. We are the judgment debtors, my lords. It was stayed, the execution proceedings were stayed by this honorable court on payment of 50% of the decretal amount, which we've already paid, my lords. Our properties were already attached there, my lords, in the execution court. But we seek to dispose of the property because we're in requirement of funds. We're ready to pay the entire decretal amount and deposit it before this court.
so now what have you
We
filed?
filed an IA for vacating the attachment order, my lords, maybe you heard.
Filed, you want the IA to be listed and it's a pending.
Please,
Who is the other side?
my lords, we'll inform them.
No, you must inform, just first survey and a copy of the IA, then mention it,
We've
then
served a
inform the
copy
date.
of the IML. We filed.
have served
we
it?
served.
We'll give you a date, but you must inform.
We'll inform.
Just give it. No, she's. Is it for listing of IA? Just to ask, give a date. Give a date, and she should take the endorsement from the other side. That's all?
Memo on.
Ma'am, you want to mention?
Yes.
Yes, tell me.
Suit for cancellation of sale deed, my lord. Court has directed.
Just ask her to wait. Yes,
Suit for cancellation of sale deed. Plaintiff executed institute order of attachment of movable property, my lord. It is for refund of sale consideration.
you are, were you a defendant?
I am for appellant, my lord.
No, there, court below. So you were the appellant, you were the defendant there.
Yes, my lord.
Now, what do you want?
I, for,
On the listing of the matter?
yes, my lord.
What is the urgency?
Uh,
Just take it, ma'am, I'll give it up.
My lords,
Just give it to her. Do it, ma'am. Only one or two?
You might send the memo. Please, sir.
Just check up, no objections, everything. Yes,
Fresh RFA, fresh RFA.
Yes, sir.
Plaint rejected by the trial court. The appellant is in the second floor. The respondent is disconnected the electricity and water connections. Hence emergency please.
now what happened? What were you before? Who filed the suit?
Suit filed by the appellant.
What were the suit for?
Suit for partition and separate action.
Acha, now what happened? Partition, they allow preliminary decree passed?
No, that is only rejected by the plaint under order 7 rule 11.
Plain rejected?
Yes, ma'am.
Okay, so just take it
Tomorrow.
ma'am, after.
My lords.
Objections removed? Objections?
office objections,
Please clarified.
No, I'm just asking to.
right?
My
lord.
Right
on the number.
My lord. Kevitin. ಬರ್ದಿದ್ವಿ.
ಬರ್ದಿದ್ದೀರಾ?
ಬರ್ದಿದ್ವಿ. Office objection also complete.
Yes,
My lords, I am respond number 1 and part in person in a writ petition filed by the petitioner state government challenging the contempt orders of the tribunal, my lords.
yeah,
Last-
it was listed now, few days back.
Yes, my lords, it
What
was,
happened?
my lords, it is listed on 12th of March, my lords. I would request if it can be heard this week or next week,
Oh,
my lords.
nothing doing. We have given you a date, 12th March will stay. Yes, now come.
Hello, bless you.
Writ appeal, madam. Pending writ appeal. I am for the respondent number 5 in this case. My urgency is The site or they are challenged the notification and they have taken the status quo in this honorable court, my lordship.
You want application?
Yes, my lordship.
Have you filed any application?
Yes, my lordship.
What is the IA number?
My lordship, IA number 1 of 25.
You have informed the other side.
Yes, my lordship. There
You
is an
informed the
endorsement.
date also.
My lord, RFA 452/22, my lord, I am for appellant. This RFA was dismissed for non-prosecution in 2022, my lord. I have filed an IA to seeking the restore the case, my lord. This honorable court has given the date for today for a hearing.
It's not listed.
It not listed.
We'll check up.
My lord.
Details of the case to the court officer.
Yes, my lord.
RFA 2023. I'm for the respondents. Order deposited award order agide. I have filed
What do you
application.
want?
Order deposited.
You are moving memo
Yes, sir. Yes, my lord.
forward.
Urgency is, my lord, already deposited amount. But I seek release. I have filed IA number 1/25.
To withdraw the amount.
Yes, my lord.
You are for the respondent.
Respondent, my lord.
Just list that IA. Have you informed the other side?
Other side inform, my lord. Yes, my lord.
You informed the date also.
Yes, my lord. Yes, sir.
That's one matter, my lords, where we had sought for preponement. Your lordships had granted a date on 20th of this month. Then the execution, I think my colleague mentioned it. Could it be had on either 17th or 18th of it?
No, when 17th, 18th, see, you have to file an early hearing, not like this.
Not 20th, my only problem is, my lords, I might have to be in Prayagraj, and that's the reason why.
It's all right, we'll accommodate
Please,
you.
my lords, please.
You get it mentioned on 20th, we will give a date.
Threat is, my lords, there's an attachment of movements.
We'll give you a short date. What is this?
My lords, if it could be for 17th or 18th, otherwise I am at your lordship's hand.
Not
either.
possible.
Not.
We will have it on 25th if you get it mentioned on 20th. We will accommodate you.
Fair enough. my lords.
That's for you to take a call.
Fair enough. There's
Yes.
another matter, my lords, if I could just mention in the
Pardon?
a threat of alienation in a plaint where the matter where the suit was rejected.
This is the same matter which you are mentioning.
Not a different.
It's a different matter.
Please,
Yes.
plaint has been rejected on the basis of revenue entries. The suit for declaration is rejected under 7 to 11 on the basis of revenue entries. Now, my lords, subsequent to the rejection of plaint, there is a sale which has been effected by the original defendant. Now, my lords, we have sought for impleading the new purchasers. Now, there's another threat because, my lords, he is also a developer. He's trying to alienate the property.
Is it a pending RFA?
Depending on it.
Of which year?
So this is of 2024. The last date of listing, my lords, is 31/7/2024. We've been trying to move this memo, my lords.
But you are an applicant, no?
I am the appellant.
You are not still a part of the party.
No, my lords, I am the appellant. I am
You are
the
the appellant.
Yes,
So
ma'am.
what do you want? Listing of the matter?
listing.
File an early hearing. Appropriate should be early hearing.
Yes,
The pending matter,
it's a pending matter.
file an early hearing.
We
Okay?
know this procedure from now on.
Yes. Now let's come the risk. Which number you want to mention? 62. Sixth of March. At the request, who appears for the other side? At the request of counsel for the appellant to state that identical matters are listed on 6th of March. Re-notify on the same date. He states that he has informed the counsels appearing for the respondents. Okay. Yes, next.
Number 55 and 56, madam. Appear for the appellant in this matter. No, not in station, some inconvenience today.
My lords,
What is the
I'm appearing for
difficulty?
respondent in this matter, my lords. They have the benefit of interim order, my lords. We are the professors and since past 1 year, we are without salary, my lord.
We'll hear it.
My lords, else
He
it
is
may be
objecting.
taken up in the next week on 19th or
Not
20th.
next week. We will give you then our date. If you have an objection, tell us. Otherwise, we will give as per our convenience.
Lords.
You take a call.
My lords, we are ready, my lords. We have no.
That's, you have heard him? That's the point. Anyway, we don't mind, provided your friend agrees, but we will not give next week. No, we will give according to our convenience.
My lords, at least in the last week, my lords.
We will give according to our convenience. We have put it to you.
My lords, we are ready today. my
Very
lord.
well. No adjournment. Next.
Serial number 31 and 32, Milan.
30 and
31 and 32, Milan.
31 and 32.
RFA 215 and 216 of 25, Milan.
Yes, what is the difficulty?
Posted on next week, Milan. My senior counsel is out of town, Milan.
Who is the other side?
Other side, I informed, Milan.
Where are they?
Hanumantappa, we informed, Milan.
You have informed
Yeah, Shankar, Shanmukappa, we are.
at the request of counsel for the appellant for an adjournment on the ground that the senior is out of station. So he also states he has informed the counsel for the respondents.
2 weeks, Milan.
We will give you as per our convenience.
Please.
23-4.
My lord. Serial number 4.
Yes,
Serial number 41, my lord. It is likely to
number-
be settled, my lord. My other side advocate is here.
serial
Maybe
number 4,
4-1.
41.
Maybe referred for mediation. my lord.
What do you want?
We are going to settle the matter. We are trying together.
You want to go into mediation? or
Yes, yes, please.
Learner counsel for the party states that the parties be referred to the mediation process under the aegis of Karnataka Mediation Center,
Please. Bangalore. B.
Bangalore Mediation Center. Noting the said submission, parties through their counsel shall appear before the Bangalore Mediation Center on. The matter shall be listed before the court with the report of the mediation center on.
Sorry.
Any,
After 3 o'clock.
3:30, any day.
14, sir.
Please. So there is an interim order.
Interim order, if any, to continue.
Much
Yes,
of it.
Serial number 6.
36, yes.
2 weeks time.
You are for whom?
And for the appellant.
You are for? What about the first respondent?
Dispense.
Arbitrate.
Dispense.
Okay, at the request of counsel for the appellant. Which is for an adjournment which is not opposed. By the counsel for the respondent. Adjourn to
9-6.
interim order, if any, to continue.
My lord, serial number 67.
Serial number,
Serial number 67, my lord. I am for the appellant. I have informed the other side, my lord. 2 weeks,
at the request of counsel for the
appellant.
appellant. For an adjournment stating that he has informed the counsel for the respondent. Which respondent?
Respond number 2, my lord. One is arbitrate.
You are for one? He is mentioning it. Which is not opposed. Just say that which is not opposed. Which request is not opposed, adjourn to
10-6.
Grateful. my lord.
Serial number 38.
which number?
38, my lord. I have informed the other side, my lord, they have filed the application for other side. The application for additional documents, I want to file objections to that.
Regarding the limitation, referring to application. And you have also directed us to submit the list of the assignments. That is ready.
I have to prepare it. my
We
lord.
don't know what you want. You want to argue the matter? You want to press the? Just wait then.
Serial number 66, my lord. So today my senior's mother's ceremony. I request of a short accommodation, my lord. I requested my learned friend also. He is present today, my lord.
Who is the other side?
I appear for the respondent.
At the request of counsel for the appellant for an adjournment which is not opposed, adjourn to
22-4.
Please.
Oblige.
With lordships kindly. Serial number 43, my lord, appellant, my lord.
short adjournment. I have informed the other side, both the councils. We
Which
have
number,
agreed.
which number?
Serial number 43, my lord.
Yes,
I have informed the other side, they have agreed also.
at the request of counsel for the appellant for an adjournment stating that he has informed the counsel for the respondent. Be notified.
4-6. May please, my lord.
Okay.
Serial number
May-
69,
please.
my lords.
Which number?
Serial number 69, my lords, I'm appearing for the appellant.
69.
I have informed the respondent also, my lords, they have no objection. May I request for a 2 weeks accommodation?
Who
my
is
lords?
for the respondent?
I appear for the.
You have heard. At the request of counsel for the appellant for an adjournment which is not opposed. By the counsel for the respondent. Adjourn to.
4-6. May please, my lord. Serial number 9, my lord. Appearing for the appellant.
Yes.
Counsel on record, if the mother is admitted in hospital, my lord. That's why we need adjournment. We are informed to that other side counsel, my lord. Kindly have it on 24th or 25th of
At
this
the
month.
request of counsel for the appellant for an adjournment on the ground that the senior counsel who is
Mr. Vivekananda.
who states that Mr. Vivekananda, the counsel for the appellant, is in personal difficulty. Is the counsel for the appellant?
Yes, yes, ma'am.
She also states she has informed the counsel for the respondent.
I appear for respondent number 1.
Just give your appearance.
15-4.
Just call the list, ma'am.
My lords,
Serial
I
number-
may mention a matter, my lords.
Bless me.
And for the respondents in serial number 25, I had informed the appellant's counsel. It's required 2 weeks to do the needful, my lords. There has been some holdups too.
For the appellant company in this matter, the appellant company is a company under liquidation, your lordship. The earliest date possible for the bench may be given, your lordships.
You said 25, no?
Yes, serial number 25.
Now, what is the position? Is it in liquidation?
My lords, the appellant is in liquidation. I am for the respondent, which is
What
BHEL.
difference it would make? Appellant is in liquidation. No, you have an award against, they must be having a decree against them.
My lords, the award was passed against me. I went in 34.
Set aside.
34 award is set aside.
But they can file it.
Please, my lords, I am not opposing. I'm just saying I'll do the needful. I need
Ma'am,
to.
what is the effect of liquidation?
Your lordships, I'm just requesting for the earlier date convenient for the bench, your lordships.
Now, this appeal is by the liquidator.
Yes, your lordships.
You are seeking adjournment.
I am seeking adjournment.
At the request of counsel for the respondent for adjournment. What is the difficulty?
My lords, some documents have not, which are not part of the paper book, which is procuring them from the trial court. Even we were not before the trial court ourselves.
Which is not opposed, adjourn to.
My lord, serial number 46, my lords.
Just 1 minute. ma'am.
16-4.
Grateful, my lords.
Next.
Serial number 46, my lords. I'm appearing for the appellant. My lords, we had engaged senior counsel, my lords. There is some personal inconvenience for her. May I request a short?
46, is this a date given matter, no ma'am?
Please, my lords.
Then why an adjournment, tell us?
My lords, we had engaged senior counsel in this matter. There is some personal inconvenience for her. We
It
have
is the other
informed,
side.
we have informed the other side, my lords. They have.
I'm
no
applying
objection.
for the respond number 2 and 3, your
At the
lordships.
request of counsel for the appellant for an adjournment. Which is not opposed. Adjourn to.
16-4.
Much more.
35.
If it could be on the last week of March, your lordship, if it's convenient to this court.
Not possible. 30?
Please.
35.
Please.
Yes.
I appear for respondent number 2 and 3, my lord.
You are appearing for whom?
Appellant.
Just wait, we will hear it. Small matter. Any difficulty? You are the counsel?
Yeah, I'm the counsel.
Just wait.
Obliged.
We come back. All the best.
Serial number 1. Shri Vishwajit Ray. Your Lordship, I'm extremely sorry, Your Lordship. Under the.
So many, this, and then you moved a
Yes,
memo
Your Lordship.
also.
I moved a memo under the impression that it's complied, Your Lordship. I need to kindly grant me 2-3 weeks.
How much time?
3 weeks. Your
3 weeks, 4 weeks to remove the office objections.
26-3. Serial number 2. Jaikar Shetty.
Yes, Mr. Shetty, what are your instructions?
That appeal filed by the state government has been dismissed, my lord.
Then what are your instructions?
Oh,
No, we say nothing. You have to tell us.
no, appeal has to go, my lord. The only thing I am requesting, my lord, in case the acquittal order is reversed.
Whatever you want to say, put it in black and white. That can be done.
In fact, I have already filed a memo, my lord.
Saying you have filed the recalling application.
No, memo is also there, my lord.
Show us that.
Latest memo.
Where is that memo? What do you say in memo?
Only that is the
You appear for whom? All the respondents?
Yeah.
All the respondents.
2/12/24 memo date. At that time, the appeal was pending. Now the appeal is also came to be dismissed.
This criminal appeal has gone, huh?
Now gone.
2000155.
Please.
Now, what are the liberty you are seeking?
Only the next page, my lord. Last.
Granting liberty sought.
Liberty to the appellant to seek for restoration of the above appeals in the event the acquittal order of 6/4/2000 made in so and so appeal is gone now. But in case in the future.
The appeal against that.
Please.
Is and what is reversed? And the acquittal order is reversed.
In case, my lord, in future.
In future.
That is the only I can get.
Say this,
That order copy, my lord, judgment copy, my lord.
No, of the trial court.
Please, appeal.
Where is that? Is it in all the cases? No, Mr. Shetty.
Now, what had happened, my lord? The first accused has filed a appeal there, my lord.
First accused, what is the name?
Pandari.
He filed. He filed.
Please, my lord.
Then, what about the others?
Others, my lord, all relatives. And the income is generated from that first accused. So, first case goes, my lord, the entire proceedings.
So the others they were not prosecuted.
They have been prosecuted.
What
and
happened
they have
there?
been discharged, my lord. That is why, my lord, the appellate tribunal has, in view of the acquittal, they have allowed the appeal there. Against that, we have filed. And now, my lord, even
one person who has filed,
main accused, my lord.
Main accused. So others would go.
Oh, please, my lord. Because income is generated from his income, my lord. Disproportionate. These are all the children, my lord, wives and other children and subsequent purchasers from those
So there was
pursuits of crime.
no prosecution for the others.
Now it is not there.
No, but similar appeals have been filed in their cases also.
No, my lord.
Only first accused, my lord, against first accused, it has been filed. No, even offense started from first accused only, my lord.
So we can.
So now the main accused, accused number 1, my lord, Pandari. He was the government employee, my lord. Disproportionate income is, my lord, from his side. So offense started from there, my lord. And these people have acquired The subsequently, my lord, properties out of that disproportionate. Now the main accused has been acquitted by both the parties, both the courts, my lord, trial court as well as this honorable court also. The
Just
only
say that now your memo is only in this case or in all matters?
in all matters.
Just show us that, man. Just show us. Memos. Now, what have you said in the other memos?
Combined, my lord, I have filed because the main case is.
Oh, you have combinedly filed?
Please. Because all the appeals, my lord, arising out of the
There was
same.
only one appeal.
Please, my lord.
There was only one appeal.
One
filed by the
appeal.
state.
One appeal.
Schedule offense, this is the main.
This is the main.
Please, my lord.
Just
They
say
have
this.
been made as a accused, my lord, due to this main case, my lord.
Because of the main case against this gentleman
Please.
Pandari.
Please. So main case has been now ended in acquittal.
This effectively your applications for recall. You will withdraw the recall applications. See, the appeal has been dismissed.
But please, my lord,
That's right.
Yes.
Shows the orders. You're right.
my only request is, my lord, let the appeal be restored, my lord, in terms of this memo, my lord, latest position, it may be disposed of.
Earlier, if they are not allowed this.
Then this.
Ultimately, result is same, my lord. My appeal will be disposed of.
Yeah.
Please.
Just say this. Mr. Shetty, the counsel appearing for the appellant in this batch of appeal states, he has filed a memo on 2/12/24, which reads as under. According to him, the reference made to a criminal appeal number 2000155 of 2018 has since been by the state of Karnataka, has since been decided, has since been decided in as much as the appeal has been dismissed. Vide order dated 20th of January 2025.
Confirming the acquittal order.
Confirming, where do we say so? No, has dismissed the appeal. Dismissed the appeal. He dismissed the appeal by the Kalburgi bench of this court. He has placed the same before, he has placed a copy of the order before this court, which is taken on record. Full stop. We find that the appeal has been dismissed. For in view of this, for non-compliance of office objections as per order dated 17/10/2022. Full stop. Accordingly, according to Mr. Shetty, it is because of that he has filed applications for. No, there is another date, I suppose, in another matter. Where is the 22/6/23?
22/6/23.
Different dates are there.
And then 22/6/23. And then 4/1/23. 4/1/23. Three dates are there, 17/10, 4/6, 22/6,
22/6,
and 4/1/23.
please, ma'am.
That's right,
Please.
4/1/23. To stop. He also states the said applications have been filed with applications for condonation of delay. Condonation of delay of 512/264 days. /433 days delay. To stop. He also states. that
And
this-
264 is there.
264 we have said. He states that the applications being so and so and so and so in each of the applications for condonation of delay of the aforesaid days along with recall applications be allowed, and the appeals be disposed of. The appeal be, what do you say in your this thing? The appeals be restored and thereafter the appeals be disposed of in view of the dismissal of the criminal appeal 200-155 of 2018. Granting liberty to the appellants.
Please.
To the appellant herein to seek restoration of the appeals in the eventuality the acquittal order dated 6/4/2017 and order passed by the High Court Kalburgi bench on 20th January 2025 is reversed. Are reversed.
Please.
That's right. You have understood?
Please.
Clear? Okay. Are reversed. Full stop. Okay. Full stop. Noting the submission made by Mr. Shetty for the reasons stated in the application seeking condonation of delay, comma, the delay of 512/264/433 days. Delay condoned and the appeals and the order dated 17/10, 22/6 and 4/1/23 are recalled and the appeals being so and the present batch of appeals are restored to their original position. Full stop. The appeals, in view of the submission made by Mr. Shetty, and also in view of the submission made by the Shetty, comma, and also because of the memo and also the subsequent facts that the criminal appeal 200-155/2018 has been dismissed, comma, the appeals are disposed of, granting liberty to the appellant to seek restoration of the above appeals in the eventuality acquittal order dated 6/4/2017
And 20th January.
and order dated 20th of January
2025
are reversed. Okay, that's fine.
Please.
Thank you.
Ah, 33 is also there. Serial number 33. That is also connected. But there is no recall application.
There is no recalling there.
Only dispose.
Show me. Is it part of this group? Is it
Please,
part of
please.
this batch?
Please.
It will be also be governed by
Same,
this?
same offense.
Where is your memo there? Which number you said?
It is there, ma'am. Last one.
Name of the mem. This also would be, there is no memo, na? Then he has, Mr. Shetty, separately, you take this separately. Mr. Shetty has drawn our attention to memo dated 2/12/24, which reads as under. He states that the criminal appeal number 200-155/2018 has been filed by the state of Karnataka, has been dismissed by the Kalburgi bench of this court with a order dated the same order,
20th of January.
20th of January 2025. Full stop. He states that in view of the dismissal of the criminal appeal, this appeal be also disposed of, granting liberty to the appellant to seek restoration of this appeal in the eventuality acquittal order dated 6/4/2017, made in special case number 6 of 2014.
14 minutes.
This is common in all the matters?
Please, madam.
Huh?
Please.
That's right, Mr. Shetty.
No,
You see your memo, please. You see your memo.
Please, please.
The last page, you say special case number 6 of
Please,
2014.
please.
So this is common in all.
Please.
6 of 2014
This case has, my lord,
is the basis foundation.
basis.
And the order dated
1.
21/2025 in criminal appeal 200-155/2018 are reversed. Are reversed in a further appeal, shall we say?
Please, ma'am.
Are reversed in a further appeal. In that also you have to say in the further appeal. So in the, you have said, criminal appeal are reversed in a further appeal. In a further appeal. Thank you.
Much up.
Nine.
9 adjourned.
10.
9 adjourned.
Nine adjourned,
Serial
10.
number 10, government advocate. Serial number 10.
Okay, where is this boy?
Well, I appear for
1% to sit here.
respondent in this case, my lord. Well, they have not deposited the amount, my lord, as per the order, interim order granted to them. There was an order to deposit 50% of the amount, staying the judgment and decree. Even after 1 year, they have not deposited the amount, my lord.
Who is respondent number 2?
My lord,
Executive engineer, PWD.
Answered.
When they show the memo parking, respondent number 2. There is no respondent
No, my
number 2 in
lord,
the.
I beg your pardon. my lord. 1
only
and 2 are state, my lord. Only a sole respondent is there.
sole respondent.
See, everything, the last order says.
Permission of free of exit. Lord, it is wrongly shown in the cause list, my lord, as.
Say issue notice to 1 and 3. There is no 1 and 3. There is
Please,
no
my
2
lord.
and 3.
Please, my lord.
Yes, now what do you say, Mr. Srinivas?
My lord, they have not deposited the amount, my lord,
Very
50%.
well, whatever is the consequence, if they have not deposited, not deposited.
My lord, I'm unable to proceed in the execution because of the stay, my lord. If that is vacated,
Wants to proceed.
From our office, communication has gone, my lord. They are seeking 1 month's time, my lord, to deposit the
There
amount.
should
is
be an
already-
application, no, ma'am, not like this.
Please, my lord.
He will go in execution, he'll take the money, then everything becomes infructuous.
Infractures, yes, my lord.
We say nothing on this. Just say,
My lord, my humble request is that, my lord,
it's
we will,
already
my lord,
there,
we will
my lord.
deposit.
now what do you want?
My lord, we seek some time for depositing the
No, you
amount.
don't deposit after 4. When was this order passed?
4 weeks, finally 4 weeks time may be given.
When was the order passed for deposit?
10th January 2024, my lord.
9/1/24.
10th January?
2024, my lord.
So
No,
you,
it's
which
on
you could not done in 12 months,
9/1/2024.
you mean to say you will do it in 1 week, 1 month?
Finally, my lord, finally.
We say
The
nothing,
humble
ma'am.
request, ma'am.
We will not repeat our orders. And must say so.
Please, ma'am.
This must come with an application giving reason why you could not deposit. What was that earlier time granted? How
Please.
much?
4 weeks, my lord.
4 weeks,
4
my lord.
weeks.
4 weeks.
Please,
So you will explain the reason why you could not?
please, my lord.
You will file an application,
Please, my lord.
the officer will file an affidavit,
Please, my lord.
then we will see.
Please, my lord.
Then just say this, suffice to state, the appeal has only unrespondent for whom Mr. V. Srinivas appears. Full stop. At the request of the counsel for the appellant, adjourn to. Now you want to take any steps, you take it,
We will, my lord.
we adjourn it.
Moreover, amount is
If there is no
3,81,000.
my lord, if there is no specific
should
order,
not
my lord,
be-
even the executing court will not proceed, my lord. May I just request, my lord, that in view of non-deposit of the amount, interim order does not sustain as of now. May I request, my lord?
1 minute, Mr. Srinivas, are we to clarify our own orders? What does it say?
My lord, he is allowed subject to condition that the appellant
That's
states.
all.
My lord, but the executing
Subject
court
to-
is not proceeding, my lord. That is the problem, my lord.
You will ask the trial court to pass an order,
Yes, my lord.
then we will look into it.
I will, my lord. I will, my lord. Much obliged. 11 and 12 are same, my lord.
4
11 and
weeks.
12 are same, my lord.
Now, are we to continue the interim order?
Lord, 9/1/24, my lord.
That's right.
There is no conditional order, my lord. It says that, my lord, stay
see that-
subject to deposit of 50% of the decretal and
Does it,
amount.
it should say so. It says subject to the
Subject to the
condition.
condition.
So once we have said subject to, it will be there.
Please, my lord.
We will file an application. Please tell us, show us.
Please, my lord. We will.
11, 12. For what?
They have not carried out the correct.
Who has filed the application for impleadment?
There is no including application. This is
How much is the amount?
3,81,000. 3,81,184. Only interest part, my lord, they have awarded 10% interest. That portion is a ground for appeal is on interest, my lord. Because the agreement does not say so, my lord.
But then what is the difficulty? You should have argued the appeal itself. That's the only issue.
Please, my lord.
Mr. Srinivas, you have anything? She says the only challenge is with regard to interest.
Yes, my lord, that's the only challenge, my lord. But, my lord, admittedly, it was a tender process, my lord. It was a commercial transaction. My lord, since for non-payment, they are liable to pay the interest, my lord. Since it was a
Then we will
commercial
set out for
transaction.
hearing, we will hear you.
Please, my lord. A date may be fixed.
Decide the
Please, my
appeal.
lord. Please, my
Yes.
lord. That could be done.
Now, where is your challenge? Where is the ground only why you are challenging the interest? Where do you say so?
Exhibit P1, my lord, is a agreement.
First, show us the ground.
Please, my lord. This was, my lord, for construction of rooms in
Are
the
you
college.
challenging only interest or you are challenging the complete?
My lord, I will argue the matter, my lord. Date may be fixed. I will argue the matter.
Now, what about these 2 and 3 whose impleadment you have sought?
Lord, the first one is regarding PF, my lord. The second one is amending the cost title. The third objection is regarding deposit, my lord.
They've been implead.
And this fourth one is regarding the CD, my lord. There is no impleading application.
Impleading application is filed by the government
You
advocate.
appear for whom?
The respondent, sir.
Respondent,
Respond.
university.
Respondent
Proposed applicant namely university.
No, do you appear along with Mr. Srinivas or separate?
Junior.
Oh,
Wait. For
My lord,
whom I,
including the university, my lord.
2 and 3 have been served.
Please.
What about 2?
Notice to
Who has filed this application for impleadment?
Not the university, my lord.
University.
no, government advocate himself, the appellant have filed the impleading application, my lord.
Impleading the University Grants Commission, my lord, and the Government First Grade College as R2, my lord. R2 and R3. That application may
Who
be.
is R2?
R2 is the University Grants Commission, my lord.
What
And
is their role?
the grants are, they give the grants, my lord. And the third respondent, my lord, the proposed respondent, they are the government college, my lord. They have no role.
Very well.
Anyway, I'll-
Just adjourn it.
Please, my lord.
Suffice to state that you have to carry out the amendments in the cost.
We will do everything, my lord.
We now the interim order
Huh?
need to be continued or not?
Well, my lord, it may be taken up next week, my lord. By then we'll clear the objections and it may be heard, my lord, finally.
Just say this, the suffice to state, as per the report of the registry, the appellant has not deposited the amount as was directed on 9/1/24, 10/1/24, 10/1/24. Full stop. At the request of counsel for the appellant,
Subject to condition.
just give it in
In
March.
11-3.
Much obliged.
Obliged.
In the meantime, notice, you will serve the notice.
Please, my lord.
Notice be served on respondent number 2.
Yes. 10, 11, 12.
Oh, all 3 are same.
All 3 are same.
But similarly, are they but different contracts?
Amount is different, my lord.
Amount is
Please.
different, not deposited there
No,
also.
no, my lord.
Same order. But separate orders.
Number 13. 13.
For the appellant.
Yes.
Plaintiff's appeal.
See, you have to serve respondent 4 to 6.
Respondent number 4 and 6, my lord, the office says. Kindly look at not the right side column. Respondent number 4 is reported to be served, my lord, by the office note itself. Is
Yes.
on the right hand column, my lord, in the cause list, my lord, my watchman kindly seen. They have stated, my lord, that respondent number 4 is in attached is already served.
Respondent number 4.
Is served.
This in Agra, sir.
Please.
Okay.
Only not in respect of respondent number 6, I may have to take steps afresh. But my lord, one request, my lord, before the trial, but my lord, all the respondents 1 to 7 have been represented, my lord, by the very same council. They are members of the very same family, joint family property, my lord, which is sought to be partition.
So what do you want?
But I will take out, my lord, it is for the second time, my lord, it's been done.
Just
First,
say
my
that.
lord, on the limitation aspect, my lord, notice was ordered. All of them were served. They did not appear. Then the delay was condoned by this honorable court. Then, my lord, fresh notice is.
Want to serve them R6?
Please.
They say that though respondent number 4 has been served and is represented through Mr. DC Nagaraj advocate, the respondent number, the notice on respondent number being incomplete. Let fresh notice be issued to respondent number 6. What about 5?
Respondent number 6 alone. Respondent number
5 is not claims.
Insofar as respondent number 6 is concerned, the report of the registry is not claimed. And as such, the service on the respondent number 5 is deemed to have been effected. Just say this, notice returnable on. Don't say notice to respondent number 6. 4, 5, then now respondent number 6. Liberty is granted to serve the counsel who is appearing for respondent.
Already served.
Even this notice have been served?
Please,
To the council.
please, to the council, same
Ye-
council is representing.
Okay, so what is this now for?
But,
Just give the file.
but only insofar as the relief sought regarding mean profits, not that has been rejected by the trial court. On the ground, not that no evidence is there, but suit for partition. Seeking not 1/3 share was filed.
You serve respondent number 6, I think better. Let them, if they don't come, then we can proceed. But what was the evidence you have placed?
No evidence, not because it was a judgment not passed on the basis of admission. I had filed a memo to dispose
But there
of.
must be some basis for you to claim. How much was the, it was for possession?
No, suit for partition.
Partition.
Not preliminary decree, not, I had sought for 1/3 share, not in the suit properties initially. Then, my lord, I modified my prayer for granting 1/8 share, which was in tune, my lord, with the defendants what they have taken. That there are 8 members in the family and it is to be divided between 8 members. Accordingly, my lord, the learned trial judge disposed of the suit, granting the 1/8 share, my lord, to the plaintiffs. But we had also another prayer, my lord, for inquiry into mean profits. That is rejected, stating that there is no evidence. But
So-
that could have been gone into, my lord, in the final degree proceedings also, that is the judgment. My lord. That can be gone into, my lord, by the very same learned judge. That is the only issue, my lord, short issue. The FDP is now proceeded.
No, what is the proceeding? What is the stage of those proceedings?
But in that, my lord, after the death of respondent number 1 hearing, who is the mother-in-law of the first appellant hearing, not the 2 legatees under an alleged will, not they have come on record. On that basis, not evidence is now being taken.
Just say you serve respondent number 6. Returnable on, just give
I
it.
request, my lord, for a date, my lord,
We are giving you a date.
please.
24/3.
Like. I'll file the amended memo, my lord, in the.
14. Serial number 14, Prakash Angadi.
This translated copy is not necessary, my lords. The lower court records are on English.
You have not filed translated copies.
No, translated, it is in English.
You have filed it?
It is not necessary. Annexure B, page 35.
Annexure B, page 45,
Page 35.
35.
It's in English, my lords, lower court records.
Show the file, it's not opening. Yes. Then what is the challenge? Tell us.
Let's seek for time, senior counsel is unwell, my lords. If we seek for a week's time, my lords.
Land acquisition matter, my lord, the arbitrator has enhanced the amount. Or that they have filed, my lord, objection under section 34 of Arbitration Act. It is dismissed, concurrently had, my lord, and concurrently dismissed, my lord, and they have preferred that section 37 appeal.
From 9,000, he is increased to 44.
Yes, my lord.
What is the basis?
My lord, say that, my lord, in point number 2, my lord. Present case, the second respondent has determined market value of land by taking guidance value of the land in Bellar village as on date of 3A notification. Though the second respondent is procedurally correct, but the value of land considered doesn't seem to reflect market value. Is a consideration. It is, my lord, it is roadside property, my lord. It fetches more than the value, even fixed by the the arbitrator.
So he makes a distinction between a guidance value and a market value.
Yes.
And what would be the basis? They will go by the guidance value.
My lord, there was comparison between my lord, the adjacent village. My lord, the arbitrator himself has enhanced the amount from 8 lakhs to 50 lakhs % per acre.
No, how could he increase? If you see page 39. Chitrapu would not come in. You see, in the present case, the second respondent has determined the market value of the land by taking guidance value of the lands at, we are concerned with which village?
Belaru village.
Belaru, as on date of 3A noted. Though the respondent is procedurally correct, he agrees what he has done, the land acquisition officer. But the value of the land considered doesn't seem to reflect the market value. If we look at the guidance value of the adjoining villages, that I think we should. Can you go to guidance value? There is a guidance value of this village. It will be this village which will determine the guidance value.
But the SLO has to, my lord, compare the, my lord, the.
How can there be a comparison when there is a guidance value? Guidance value will determine. There can be any reasons for villages to have different guidance values. Now, this village has a particular guidance value. Now, what he says is he agrees what the land acquisition officer has done is right. But he says those villages guidance value is there.
No,
that's not the basis. What is the relevance of then guidance value?
My lord. But my lord, kindly see the after that, my lord, the one. Ninth line from the, my lord, bottom of point 2. My lord says further the arbitrator in previous arbitration cases from Bailaru, so and so, has increased the compensation from 8 lakhs per acre to 50 lakhs per acre.
Same village.
Same village.
Same notification.
Yes, my lord.
What do you say?
That's the senior is not in station. That's it.
We want to know, did you challenge this? Have they challenged this?
No. Yeah.
This case.
Even they don't mention it in before, my lord, the trial court. That they have challenged it.
The learner counsel for the challenge in this appeal is to an order passed by the 4 additional districts and sessions judge Mangaluru dated 7/4/23. The petition filed under section 34 of the Arbitration and Conciliation Act 1996, whereby the challenge by the NHAI was negated. Full stop. The learner counsel for the respondent number 1 has tried to justify the order of the arbitrator and also the additional district judge by drawing our attention to page 39 of the paper book, where according to him, and how much he has increased, the arbitrator?
From, my lord, for 44,800, my lord.
No, he says 8 lakhs per acre to 50 lakhs per acre.
Then it will be, my lord, 50,000.
How much he has granted?
For it, my lord, it is 50,000 per cent, my lord.
Now, how much that translate to for 1 acre?
Yes, my lord, 50,000 per cent.
Okay.
So it is 50 lakhs per acre, my lord.
So it would be 44 lakhs.
Yes,
per acre.
Per acre.
To just say that, ma'am. To state that with regard to the same village, that is Belaru, same notification?
Yes, my lord.
Huh?
Same, my lord.
What
Is
was
the-
the notification here?
Patient 8/9/2012. Regarding same arbitration cases from Bailar village.
Right, which notification?
Notification.
As with regard to the same village, Bellaru has fixed the has increased the compensation from 8 lakhs per acre to 50 lakhs per acre.
Please.
Mr. The learner counsel for the appellant shall take instructions on the submission made by the learner counsel for the respondent number 1 on the next date of hearing. Re-notify on.
Please. Oblige.
Serial number 15, previous 9.
Yes. But what has happened is, my lords, who is the other side?
Previous 9.
Just pass over, let's see. Can it be called at 2:30 minutes? We will, I think it will be 2:30 only. We'll not to call before that.
Data, notes, I have some difficulty.
Yeah, no issue.
Please,
Do you want at 2:30?
yes, please.
16.
For the appellant waiver, I seek weeks time to take steps to respond number 1 mal. He is the contesting respondent. Weeks time may be
No,
granted.
but what is the case on merits?
Case on merits for allotment of sites mal. The first court has passed the order stating that we have to allot one site, either in the one Malathalli place or any other place. So far as any other place, we have no objection. Only because Malathalli, there is no sites are available. Typed page number 53 mal. There are other contentions also. The first respondent is the person who has got the order.
Right from 2008, they have suffered an order, my lord.
You are appearing for respondent 1.
Please.
Huh?
Not the contesting respondent, the government.
Respondent number 1. Respondent number 1, it is not served.
2.
So now what is your case?
My case is, my lord, majorly I am filed this appeal that any other fresh layout has been formed, we are ready to give the site to him.
How is that possible?
Yeah, because from the beginning, it is our contention that sites in this layout is not available.
But what have you produced? See the finding in paragraph 11.
Paragraph, my lord.
That's right.
11.
Level of High Court judgment, my lord.
That's right.
And it is favor of the first one, and that it is relevant to note that the said contention is also what was before the tribunal, and that the has produced the copies of such that is some of the sites they have on seniority basis they have allotted.
Where is the seniority? You have not produced that also.
That also not produced.
Then
That is only our contention is,
You have to make good your case. We have a seniority, we have strictly gone by the seniority, and this gentleman is at bottom.
what has happened, my lord, is earlier when the first court, case has been conducted, administrator was appointed. He has not proceeded with the matter properly. That is why we have suffered the order. Then same order has been upheld by all the courts.
Now, what is the direction given by the tribunal? To allot him a plot?
Yes, madam. And he has to pay the balance amount also.
At which rate?
That present balance amount is at present very meager amount. Even then, that amount also he has not paid.
But otherwise you will be able to pay the plot to him.
No, I'm not available in this layout, my lord.
Just say that respondent number 2, respondent number 1.
One.
Is still unserved. Let notice be issued to respondent number 1, return below. He is respondent number 1 now.
With respondent number 1 is the contesting.
You serve him, let him come.
Much all.
Your lordship, in this case, I am for appellant. I sought instructions from my client that the respondent is now again staying at the same address. Only her son has shifted to a new house and the respondent is still staying in the same address. And so lordship, the notice can be served to the same address as mentioned in cause title.
You want to serve them?
And to the same to the address mentioned in the same in the cause title, same address. And apart from this, your lordship, now the respondent has filed execution petition, your lordship. Now I request your lordship to kindly stay this impugned order, and I'm having one ground.
You will serve the other side.
I will, sir.
Yes. Notice be issued to the respondent.
Your lordship, just one submission. I would like to make. Your lordship, I request this court to kindly pass the order, because your lordship, only one ground I'm relying upon.
Why are you appearing in the execution proceedings?
Yes.
Why don't you serve him there?
I will serve. I have.
When is the now date before the executing court?
22nd.
Serve him there.
Your lordship, but the presiding officer there sitting is asking for stay order, your lordship. Because they are getting attachment of the properties. Just one submission, your lordship.
Don't serve the other side. How many have to be served? There is only single now.
Only one. Yes, respondent is not a lawful owner at all, your lordship. He is not a bona fide litigant.
Let notice be issued to the respondent number 1. Liberty is granted to the counsel for the appellant to serve the respondent before the executing court. Okay?
At the status quo, your lordship.
What status quo? Who is in possession?
Owner.
All right.
But my materials or my salon is.
That we will take. Let him come. Let him come.
Your lordship is not at all a bona fide litigant.
We will come, please. Just serve it. Just give it in March.
25-3. Serial number 18.
Lord, for the respondent, Lord, I have prepared a very brief synopsis. But I'll not have more than 15-20 minutes. Lord, can I proceed, Lord?
Yeah, you
Yes.
want to start.
Lord, I have prepared a synopsis. Lord, I have about 6 formulations to place before Lordship after having heard the learned senior counsel appearing on behalf of the appellant. Lord, my first formulation would be that there is indeed a prima facie case against the petitioner for investigation, because all that we have done thus far is only conduct investigation. Lord, there are a few.
No, conduct investigation qua him or just only calling him to record
Qua
his
him.
statement?
Qua him.
Qua
We can
him.
subject him to investigation is my case. I am saying that there is a prima facie case to investigate the petitioner. Subject him to investigation.
But it appears the impression was that he's been calling to record his statement with regard to someone others, not him.
No. With him only.
With him.
With him. Lordship would bear. There are a few undisputed and admitted facts. Lord, please have a look at them. Lord, which will make out a case for investigation against the petitioner. Lord, the first undisputed fact, Lord, as your Lordships would see at page 1, is that the petitioner has been a chairman of the Shumaga District Cooperative and Credit Bank for a period of 23 years. That's not disputed. As chairman, the petitioner had administrative control over the bank and its employees. Accused number 1 in the predicate offense, Srimati Shobha, was appointed during the set tenure of the petitioner. The main accused, who is responsible for granting the loan, was appointed during his tenure. He was the chairman. Then Lord Lordship would kindly have a look at the second page. On 17/7/2014, the Doddapete police registered FIR in crime number 325 of 2014 in respect of issuance of fraudulent gold loans issued by the Shumaga DCC Bank against fake gold by creating fake documents, leading to misappropriation of 63 crore. Later, the investigation was transferred to CID. This is all admitted. Police filed charge sheet in crime number 325 of 2014 under various sections of IPC, including 471 and 120B, both of which are scheduled offences under the PMLA. In the said charge sheet, petitioner was arraigned as accused number 15. So originally he was arraigned as accused number 15. Additional charge sheet was filed subsequently for offences under section 409, 402, read with 36 of IPC. Though the petitioner name was dropped from the first charge sheet, petitioner was added back as accused number 15. So therefore he was brought back. In a separate proceeding bearing crime number 4 of 2014, the petitioner has been charged for the offences under section 13(1)(e) and 13(2) of the PC Act. However, petitioner claims that he has challenged the grant of sanction in the said proceedings and that further proceedings had been stayed by this honorable court. Now, my lord, these are all the admitted facts. Now, please have a look at two principles which I have culled out, one from Vijay Madan Lal Chaudhary, the other from Pavna Dibor, which your lordships will find at page number 3. The first principle is existence of predicate offence is sufficient for registration of ECIR and commencement of investigation under PMLA. So the moment there is a FIR, doesn't matter against whom. If there is a FIR in respect of a predicate offence, I can register ECIR and commence investigation. Then please have a look at the second one, which is in Pavna Dibor. The investigation can cover even those that are not accused of the predicate offence. No, my lord, I heard my learned friend appearing on behalf of the writ petitioner repeatedly say that there is no, I am not the accused. I have been, although I was an accused, later I was moved into other offences. So that doesn't help the cause of the writ petitioner at all.
No, but tell us, why do you say the investigation cover not, is it relevant? But you say so he is an accused in that the other matter.
No, my lord, that number one, that he is an accused in the other matter. He continues to be an accused, though may not be for a predicate offence. Number one.
No, under 13, it's a predicated offence.
Yes, my lord, 13 is a predicate offence. Currently, my lord, currently he may have secured a stay in a 482 proceeding.
What is the effect thereof?
My lord, I would say, my lord, there are judgments on either side. A mere stay, honorable, the Madras High Court has said that a mere stay is not sufficient for stoppage of the investigation itself. If it is quashed, then, my lord, I have nothing to proceed. If it is quashed. But a mere stay, my lord, the recent judgment of the Honorable Supreme, my lord, I believe last time when your lordships inquired, what is the, on what ground was it challenged? The submission that was made was on the ground of sanction. No, my lord, the latest judgment by the Honorable Supreme Court is a mere defect in the sanction alone is not sufficient. It should be coupled with miscarriage of justice. So therefore, my lord, on these technical grounds, my lord, obtaining stay should not come in the way of me conducting the investigation. Nevertheless, my lord, under section 50, subsection 2, we have a right to summon even a witness. My lord, this man has been a chairman of the bank. He knows how the employees were appointed. He knows about the transactions that have taken place. Lord, the allegation is that loans were granted without following the due procedure. So this man knows about how the loans were granted. He may not have granted. He is trying to build a wall. He is trying to use the facade of the first accused. But the first accused is his appointee, and she was acting under his instructions. So therefore, why should we not summon him for investigation? When that first accused was appointed, did she seek necessary approvals? Whether the procedure prescribed in law was followed, whether the RBI guidelines were followed. But this man is everything happened during his tenure, which is why, my lord, I'm beginning with my factual assertion that he was the chairman of the bank for a period of 23 years, and the predicate offense is in respect of that bank.
No, but you're right, but what you are saying is very well, in a way, there is no predicated offense qua him.
Need not, yes, my lord. My answer is yes, and my corollary to that is it need not be. The law is not that we investigate only those who are accused
So
of the
what you are
predicate.
saying is this, then. Though there is an offense under which is a predicated offense where he is the accused in the other matter, but since he has challenged the sanction, there is a stay. Assuming for a moment that that stay would operate in his favor, it is as good as today there is no predicated offense qua him registered till such time that sanction issue is decided. But you are still within your rights to issue summons to record his statement.
True.
May not be qua him,
Yes.
but qua others.
Absolutely. Absolutely. So long, my lord, so long as there is a ECIR, so long as an investigation is being carried on pursuant to that ECIR. My lord, this writ petitioner does not dispute the existence of a predicate offense against others. There are several others against whom the predicate offense, the investigation is continuing, the trial is continuing. So it does not help this writ petitioner in contending that I am not an offender for a predicated offense, and against the provisions, the proceedings under PC Act he has obtained a stay does not help him. So long as there is a predicate offense which has been committed, as against which I have registered a ECIR and I am conducting an investigation, in respect of that investigation, I can summon any person as a witness for two things, either to record his statement or to ask him to produce certain documents. And my lord, to find out whether
Those documents which he will produce would be qua others or qua himself.
No, we do not know at this stage of time. If later on we find that he has received certain proceeds of crime.
But your summon doesn't talk about a general information which you are seeking.
No, my lord,
you see a summons.
The summons, my lord, is as per form number 5 under the rules. My lord, the validity of this form and others has been discussed in Vijay Madan Lal and in subsequent judgments also. So we have a prescribed format. We follow the same format of the summons. And there is
No, we are not on the format. We are seeing the contents of the summons. See.
The contents, we fill up the date and time, that's all.
No, you see this summons.
Yes, may take Rosh. Page number really summons.
24 and 24. We go to make sure.
My lord, page 91.
Mm-hmm.
This is the typical format, not which we use. We just fill up the details required.
No, but they see the contents.
Yes, my lord, I'll read for lordship's benefit.
No,
Other than what is handwritten, rest all is standard format.
That's right. But what is handwritten is something concerning him.
Yes.
That is that permissible?
It is concerning him, yes.
Is that permissible?
Yes, my lord, because we have to find out whether he is a recipient of the proceeds of crime. My lord, somebody who he appointed, who is the prime accused, what if he has received the proceeds of crime from her?
So that is what is being said is something we are calling him to elicit that he should elicit information qua himself, not for others.
Yes. No, it could be both, my lord. It could be both, my lord. Please have a look at the documents that we have asked him to produce. Number 1, Aadhaar card, passport size photo and passport. This is only for identification. Details of all immovable properties held in your name and in the name of your family members. This, my lord, obviously to find out whether he is a recipient of any proceeds of crime, date of acquisition and other things, because we have already discovered that prior to the registration of the predicate offense, he had only some one property. But now, my lord, we have discovered the total properties that he holds is about 37.
No, but tell us one thing. If suppose you find that he holding properties,
Yes,
then that would be an evidence which against him.
it would be. If there is no sufficient explanation, and if we are, let us say, my lord, let us say that he has received, he has purchased certain property for which the money is paid or transferred by accused number 1 in the predicate offense. Then, my lord, accused number 1 would had access to the proceeds of crime. She has transferred it to him, and therefore this would be a proceeds of crime as well.
So then will it be in the nature of an investigation, or will it be in the nature of a statement qua the predicated offense against others?
This all, summoning him is all part of the investigation. It is part of the process of investigation.
But which includes qua him.
It includes qua him.
Now let's assume hypothetically, Mr. Kamath, there is no predicated offense against anyone, against one person. Now, you may say so, insofar as a person is concerned, I am within my rights, I can call, record the statement only for the purpose of eliciting or doing investigation when the predicated offense is qua others, not against one person, this person.
Yes.
And we have called it.
Against the person summoned.
Against the, not against the person summoned.
There is no predicate offense against the person summoned.
That's right. But against the others.
Yes.
Now, if that be so, can there be an investigation? This is what we are just want to know.
It would be.
Investigation against a person who is not involved in the predicated offense.
This is covered under Vijay Madhula Chodha in Pavna Dibur as well.
Shows that.
It is permissible. In fact, I made a copy of Pavna Dibur. In Pavna Dibur, would your lordship kindly have a look at the conclusions in the last penultimate page, in particular 31.1. Hmm. 31.1. It is not necessary that a person against whom the offense under section 3 is alleged must have been shown as accused in the scheduled offense. This is one step beyond investigation. I can go and I can charge someone that you have committed an offense under section 3, even though he may not be an offender for the predicate offense. Because, my lord, predicate offense is completely different from the offense under section 3. It's an independent standalone offense. For example, the predicate offense may be cheating, but the money generated out of cheating can transfer to so many people. A and B may have committed the cheating, but the money can be handed over to C, D, E, F, and from F it may go to G. G will be guilty of an offense under section 3. So therefore, my lord, it does not help the cause of all these writ petitioners in claiming that I am not responsible for the predicate offense. And my lord, we need to find out the money trail. Money trail can take place in so many ways. There can be a direct transfer, there can be handing over of cash, there can be assistance in purchasing a property, there can be purchase of movable properties. All this, my lord, this we have to investigate. We have to essentially ask the details of the person concerned, his properties and his family members' properties as well. Because we see that the properties are consistently purchased in the name of family members. Otherwise, my lord, we will never be able to detect where is the money trail and how the proceeds of crime has changed hands. So therefore, this is at the very initial stage. My lord, lordships will set a very, very low threshold for me to summon him. My lord, in fact, I'm not sure if the other side cited the judgment of a learned single judge of this honorable court in the case of Natesh in that Muda case. My lord, there the other side relied upon a judgment of honorable Rashmi Metallics. Rashmi Metallics case, where, my lord, the learned judge of the Honorable Kolkata High Court refers to the threshold under section 19, which is the power to arrest, and for section 17. My lord, the yardsticks for 19 and 17 are completely different. For example, if I have to arrest a person, I should record reasons that he is guilty of that offense. Lordship will kindly notice how high the threshold is. I have to come to a conclusion that the person whom I want to arrest is guilty of an offense under the Act. But here there is no such prescription at all. I can summon any person in respect of an investigation that I am conducting. That is the language used under section 50. Therefore, my lord, Pavanadipur very clearly says that it is not necessary that a person against whom the offense under section 3 is alleged. Now, my lord, I am not even alleging. Against this writ petitioner, I have not even made an allegation that he is guilty of offense under section 3. I am saying, please show me your records. I want to find out whether you are recipient of any proceeds of crime. Not why should I not that, my lord? The law says I have the right to summon him. And subsection 3, my lord, says that every person is bound to appear. Lordships will also take into consideration the mandate in law that when I summon, that the person summoned is bound to appear.
So you are relying upon this Pavana.
That principle which is laid down in 31.
If you see the other conclusions drawn.
Yes.
31.2.
I may read, my lord. Even if an accused shown in the complaint under PMLA is not an accused in the schedule offense, he will benefit from the acquittal of all. My lord, this may not help us at all.
31.3.
Yes, my lord. The first property cannot be said to have any connection with the proceeds of the crime, as the act constituting schedule offense were committed after this also, my lord, we don't know. We are at a very nascent stage.
No, but the only thing is, reading of you say that this investigation is only to see whether the proceeds of crimes are with him. The proceeds of crime are with him.
My lord, I will not confine to that. I am now investigating a proceedings which I have registered pursuant to a FIR. Now, in the course of investigation, 3 possibilities. Number 1, I may not find anything at all, that he is not a recipient of any. So therefore, we do not proceed against him. Number 2, we may find that he has information and he is a recipient of the proceeds of crime. Now, if he is a recipient of proceeds of crime, then we have a right to charge section 3 against him. So these are the possibilities.
Okay.
And to even find out whether he is innocent, whether he has received any proceeds of crime, we should look into the records.
Look into his records.
Yes, look into his records.
Okay. Okay. Yes.
My lord, in the same breath, my lord, there's one more latest judgment, my lord, which we laid hands upon very recently. An October 24 judgment by the Honorable Supreme Court. This was also, I'm sorry, 19th December 2024. This is a proceeding in which a summons issued under similar circumstances was challenged on the ground that the schedule offense was caused. Very short judgment, may I read, my lord. The only issue for consideration is as to whether the High Court is justified in quashing the summons on the premise that the respondent has been discharged in the predicate offense. We also note that the said order was passed by taking into consideration the submissions made on behalf of the appellant, wherein it was stated that the proceeding against the respondent may be closed. We are limiting ourselves to the question of law. What has been issued to the respondent is merely a summons, Lordship would mark that. Simply because he has been discharged in the predicate offense, a court cannot quash the summons. The question as to whether the respondent would be arraigned as an accused or not is a matter which has to be decided at a later stage. In that eventuality, it is well open to the respondent to raise all relevant contentions for the aforesaid purpose, including the submission that since the predicate offense has been quashed, the subsequent action of the appellant arraigning him as an accused in the PMLA proceeding would not be sustained in the eye of law. Suffice it to state that at this stage, we are dealing with a summons that has been issued. In such view of the matter, the impugned order stands set aside and the appellant is at liberty to proceed. I was the appellant, to proceed in pursuance of the summons that had been issued. However, we make it clear that all issues are left open to the respondent in the event of him being arraigned as an accused. Considering the facts and circumstances of the respondent, we direct respondent may not be arrested as beyond responding to the summons, subject to the condition that he shall continue to cooperate with the investigation. The impugned order is set aside accordingly and the appeal stands allowed. So, my lord, leave was granted, my lord. So, therefore, this is a final order which was passed on merits. So, my lord, in respect of a person against whom he was discharged from the offense, even in those cases, my lord, I was permitted to continue the investigation.
Because what you are investigating according to is only confined to section 3.
Yes. Yes, my lord, of course. I have no other jurisdiction. No, I am not looking into the predicate offense at all. That's not, I will go to the extent that is not my business at all. I have no jurisdiction. I will confine myself only to section 3. In particular, first to find out is whether he is a recipient of proceeds of crime, whether he is in some way connected to the proceeds of crime as laid under section 3.
See, you see section 3.
Yes. My lord, in this case, my lord, the fact that there is a proceeds of crime, my lord, even the writ petition is not disputing. Gold loan has been issued. The authorities have found that it is fake gold loan. Money has been received. There are a lot of money transactions. There is no dispute by the writ petitioner of the existence of the proceeds of crime. The writ petitioner's contention is that I am not responsible. At this stage, I am not an offender. Please look at the FIR and the charge sheet. I am not named. But he is not named for the predicate offense. It is my responsibility to find out whether he has touched the proceeds of crime. If he has touched in any manner as laid down under section 3, then, my lord, I have a right to proceed against him. Now, how do I find out whether he is a recipient of proceeds of crime? Only by looking into the properties that he owns, only by looking into, and also by looking into his bank accounts. What is his difficulty? He should furnish his bank account and the property details. Section 3, my lord, if I may read. Whoever, please look at the sweeping language that the law uses and validity of which has been upheld by the Honorable Supreme Court. Section 3. Whosoever directly or indirectly attempts to indulge or knowingly assists or knowingly is a part or is actually involved in any process or activity connected with the proceeds of crime, including its concealment, possession, acquisition or use, and projecting or claiming it as untainted property, shall be guilty of an offense of money laundering. I'll pause here for a moment. What if this chairman who appointed A1, accused number 1, who was mainly responsible for the guarantee, had assisted, had aided, indirectly assisted? All these are subject matter of investigation. So we will have to find out only by recording his evidence.
Okay. Anything else?
Then, if I may come back to my written note. I was at page 3. So how, I am attempting to pursue your lordship is, there are a set of undisputed facts that he was the chairman and the predicate offense is there. And then I am placing reliance on 2 principles, that existence of predicate offense is sufficient for me to initiate investigation, and investigation can cover only even those who are not accused of the predicate offense. Now, my lord, please have a look at item C in page number 3.
Your submission is because that the other case is pending against.
Yes.
Though there is a stay.
Yes. No, there is a stay only against this writ petitioner.
No, very well. What you are saying, is it your submission? There is a predicated offense.
Yes.
That's all.
Yes.
So it connected with the investigation is being carried out.
Yes. And as part of that investigation,
to find out the trace. That's what you're saying.
That's Lord, please have a look at item C at page 3. Lord, I'm deducing something, for your lordship's Lord. First thing, there are predicate offense in respect of which proceedings are ongoing before the jurisdictional courts. The said proceedings are in respect of issuance of gold loan by the bank, which functioned under the chairmanship of the petitioner. The petitioner, being a chairman of the bank, which is the subject matter of investigation, would be aware of the procedure followed for verification of gold loan application, approval process, verification of gold and other securities, and issuance of gold loan. The petitioner has not denied, questioned, or doubted the allegations against the accused facing the charges for the predicate offense. Petitioner has not denied, questioned, or doubted the misappropriation of ₹63 crore by the accused facing the charges of the predicate offense. Section 2(1)(u) of the PMLA, as per Section 2(1)(u) of the PMLA, 63 crore forms the proceeds of crime. As such, the existence of proceeds of crime is not in dispute. To understand the generation of the proceeds of crime and to detect the money trail, it would be necessary to understand it should be read as understand, the modus operandi followed by the staff of the bank. Being the chairman, the petitioner would be aware of the processes followed by the bank staff. The petitioner, being the chairman, would have valuable information about the process followed for the verification of the loan application, verifying security, and for grant and issuance of loan. Therefore, authorities are well justified. Now, my lord, to demonstrate that I have followed the procedure prescribed under Section 52, my lord, I have prepared a table, my lord, which your lordships will see at page 5. What are the ingredients of the provision and how I satisfy? My lord, the first ingredient is that there should be a predicate offense under Section 52. And what is, yes, there is a predicate, there are two predicate offenses.
Predicate offense may not be against the person summoned.
May not be.
But there is something in existence.
Yes, yes. Number 2, there should be an investigation under the PMLA. So my answer is, pursuant to the aforesaid predicate offense being registered, respondent has registered ECR number so and so. Pursuant to such ECR registered, investigation is ongoing. Number 3, power to summons lies with the director, additional director, joint director, so and so, including assistant director. In this case, summons is issued by assistant director, so therefore the jurisdiction is there. 4, my lord, the language used is, any person may be summoned for recording evidence or for production of documents during the course of investigation or proceeding under the Act. Now, my explanation is, petitioner has been summoned during the course of investigation in respect of ECR number so and so for the purpose of production of documents. It is immaterial whether the petitioner is an accused in the predicate offense or not. And finally, the summons should be as per the format prescribed in form number 5. The prescribed format does not require statement of detailed reasons as to why the petitioner is summoned. So therefore, my lord, my respectful submission would be that the summons satisfies the requirements of Section 52. Then, my lord, my learned friend, while arguing the other day, he referred to about 3 propositions. My respectful submissions would be, if those propositions are accepted, it will be literally turning the PMLA on its head. My lord, I have reproduced the 3 submissions which he made at page 6. His first submission was that the summons should state as to why the addressee is summoned. My lord, there is no such law. There is no such law. At the summons stage, I am not required to, because it's a very, very preliminary nascent stage. I can only say, please come, I want to record your summons, record your statement, or I can ask him to produce certain documents. No court, including any High Court or Supreme Court, has said that I should disclose. Number 2, my lord, his proposition was that a third party can be summoned under Section 50 subsection 2, but not someone who is connected to the case against whom no predicate offense is alleged. So my learned friend was trying to build a case. Third party could have been summoned, but I cannot be summoned because I was the chairman, but I have not been charged with a predicate offense. Not I thought, my lord, his submission should have been that any third party could have been summoned. But my lord, I mean, why the language used is that any person during the course of investigation. So long as I am able to
How would you answer this, Mr. Kamar? Let's assume that he is an accused in that. In 13, there is a stay. The stay is vacated. He becomes an accused there. Now, can you call him as an accused? What would be your submission on that? You're getting the point. I hope we are clear. Today, he is an accused under 13.
No, at this stage, not by.
No, you're right.
I got it. I will answer this way. At this stage, my lord, we do not know what is his link to the offense. We want to know, we want to first verify if he's a receipt. Lord, 63 crore has been misappropriated. There is no doubt about it. 63 crore has been misappropriated. There is no challenge to that. We want to know whether he has received any part of that 63 crore. If he has
Now,
received.
suppose for a moment, if one person was an accused, you could have issued summons in the manner which you have done. Let's put it this way. And a person is an
No,
accused.
even, my lord, I can issue a summons to him only at the initial stage to find out whether he is whether he is a recipient of the proceeds of crime. Even if he's merely because he is an accused under the predicate offense, I cannot summon him. I mean, he can be, he may have committed the predicate offense, but he may not have touched the predicate offense. I mean, the proceeds of crime. There is a possibility. I will get a right to proceed against only those persons who are associated with the generation of the proceeds of crime, or who are recipient of the proceeds of crime, or who have received it but projected it as an untainted.
Who are not part of predicated offense.
Yes.
But they may have the proceeds of crime.
Oh, straight away then offense.
They may not, but I want to ascertain. That's your case.
Yes.
It's a case?
Yes, that's my case.
No, we are saying, let's assume for a moment, these are in what submission you have made is in the eventuality. The person is not part of predicated offense, but I am calling it to know the trace of the money.
Yes.
That's right. Maybe that person also has the
Yes.
access to that money. But what would be the position when there is a person who is actually an accused? Can you now take in that eventuality against that accused a similar summons? We want to know.
Yes, my lord. My lord, at this stage, whether he is an accused or not does not make any difference.
But tell us one thing, we don't know, you have to tell us on this. But he is a part of the predicated offense in terms of that has been registered.
Under the PC Act.
That's right.
Yes.
If yes, today what is what is separating, he may be relying upon there is a stay.
Yes.
That offense is as good as nothing against me.
Yes.
But you may say, suppose assuming for a moment the stay is vacated, there is an offense which is there against him.
Yes.
He is an accused.
Yes.
Can you in that eventuality, that's the reason we are drawing.
Yes, in that eventuality also I can summon him.
That's right.
Yes.
How would you, on what basis, what would be the position of law?
Once again, to find out whether he has received any proceeds of crime.
So let's.
Or whether he had anything to do, whether he has assisted in the process of or activity of generations of proceeds of crime.
So if we are only not on the first principle, that is that he is not an accused, then you are submitting. Even against an accused, can you ask him to produce?
In fact, no, that is covered under Vijay Madan Lal.
Show us that.
Vijay Madan Lal very clearly says.
Show us that. Let's see.
It says during the course of investigation, if someone is found to have committed an offense, then we can charge him then.
No, we are on a different proposition, Mr. Moore. You have issued summons against an accused. Let's assume.
Yes.
These summons are against an accused. Can in law, you can issue notice and carry out an investigation against a person against whom there is a predicated offense?
Yes, my lords.
For the purpose of section 3.
Yes, my lords, I can.
Show us that.
No, I mean, for that, my lord, on first principles under section 3.
No, very well. See, that's because whatever you have argued is that a person who doesn't have a predicated offense, who is not part of the predicated offense, I am doing investigation. I can do larger investigation to know this trace of money. Now, when you are calling upon an accused to say that you get this.
Yes, yes.
And he's an accused, can you in law call such an accused and record his statement?
Of course I can. I can.
Now, does Vijay Lal Chaudhary refers to that? Which paragraph?
Vijay Madan Lal, my lord, as far as section 50 is concerned, it begins at para 422. In the compilation that your lordships have, it could be page number 212. The SCC page number. SCC page number could be 212.
212.
If your lordships got para 422.
Yes.
The validity of this provision has been challenged on the ground of being violative of 23. Not, we can probably skip that. And then they reproduce the powers of the authorities. Section 50, 423 forms part of chapter 3 of the 2002 Act, which deals with the matters connected with authorities referred to in section 48 in the same chapter. Section 50 has been amended by Act number so and so again. Nothing much would turn on these amendments. By this provision, the director has been empowered to exercise the same power as are vested in a civil court under CPC while trying a suit in respect of the matters specified in subsection 1. This is in reference to section 313 of the 2002 Act dealing with the powers of the director to impose fine in respect of the acts and commission and omission by the banking companies, financial institutions, and intermediaries. From the setting in section 50, from the setting in which section 50 has been placed, and expanse of empowering the director with the same powers as are vested in a civil court for the purpose of imposing fine under section 13 is obvious, very specific, and not otherwise. Indeed, my lord, this subsection 2 of section 50 enables the director, so-and-so additional director, joint director, deputy director, assistant director, to issue summons to any person whose attendance he considers necessary for giving evidence or to produce any records during the course of any investigation or proceeding under this Act. We have already highlighted the width of the expression proceeding in the earlier part of this judgment and held that it applies to proceeding before the adjudicating authority or the special court, as the case may be. Nevertheless, subsection 2 empowers the authorized officials to issue summons to any person. We fail to understand as to how Article 23 would come into play in respect of process of recording statement pursuant to such summons, which is only for the purpose of collecting information or evidence in respect of proceeding under the Act. Indeed, the person so summoned is bound to attend in person or through authorized agent and to state the truth upon any subject concerning which he is being examined or is expected to make statement and produce document which he is being examined or is expected to make and produce document as may be required by virtue of subsection 3 of section 50 of 2002 Act. The criticism is essentially because of subsection 4, which provides that every proceeding under subsections 2 and 3 shall be deemed to be a judicial proceeding within the meaning of sections 193 and 228 of IPC. Even so, the fact remains that Article 20, Clause 3, or for that matter, Section 25 of the Evidence Act, would come into play only when the person so summoned is an accused of an offense at the relevant time and is being compelled to be a witness against himself. This position is well established. So therefore, my lord, this para 425, my lord, would make it very clear. That so long as an investigation is being carried out, the authorities are well justified in summoning any person in connection with that. Here, my lord, the person summoned is not a stranger to the offense. The offense is giving away of gold loans by a bank, and this gentleman was a chairman of the bank for 23 long years. So he is no stranger. So we are well justified in summoning him to record his statement on and to call upon him to produce the documents. Of which judgment? Is yet to be coming. Would your lordship also have a look at 431, para 431? That's relevant. In the context of 2002 Act, it must be remembered that the summon is issued by the authority under section 50 in connection with the inquiry regarding proceeds of crime, which may have been attached and pending adjudication before the adjudicating authority. In respect of such action, the designated officials have been empowered to summon any person for collection of information and evidence to be presented before the adjudicating authority. It is not necessarily for initiating a prosecution against the noticee as such. The power entrusted to the designated officials under this act, though couched as investigation in real sense, is to undertake inquiry to ascertain relevant facts, to facilitate initiation of or pursuing with an action regarding proceeds of crime, if situation so warrants, and for being presented before the adjudicating authority. It is a different matter that the information and evidence so collated during the inquiry made may disclose commission of offense of money laundering and the involvement of the person who has been summoned for making disclosure pursuant to the summon issued by the authority. At this stage, there would be no formal document indicative of likelihood of involvement of such person as an accused of offense of money laundering. If the statement made by him reveals the offense of money laundering or existence of proceeds of crime, that becomes actionable under the act itself. To put it differently, at the stage of recording of statement for the purpose of inquiring into the relevant facts in connection with the property being proceeds of crime, crime is, in that sense, not an investigation for prosecution as such. And in any case, there would be no formal accusation against the noticee. Such summons can be issued.
So what is being said in this para is, though accused of predicated offense, you may not be involved under section 3. It can be an eventuality.
Yes.
It is only to ascertain, though a person is in predicated offense, it is only to ascertain whether you are part of, or you can be proceeded under section 3.
Yes. After gathering.
After gathering evidence. It's for that purpose you summons are being.
So which is why their lordships are saying, don't confuse it to be a criminal investigation for prosecution. It is like an inquiry, civil inquiry.
Not an investigation against predicated offense.
No, I cannot do that.
That's what.
Obviously,
you're right. No, very interestingly, no, what is being said is, there is some observation here. If you see the later part of that
Yes.
paragraph, 7th or 8th line from that paragraph, just above 432.
Yes.
In such a situation, at the stage of issue of summons, the person cannot claim protection under 23
Yes.
of the Constitution.
Yes.
You can't claim protection.
We can
Look
claim
here,
protection.
you are calling me whereby to take
You are
evidence
compelling
against
me.
me.
Yes. I'm not, this principle has been reiterated in subsequent judgments as well. This 23, but he cannot say, I have brought a couple of things which a person.
Statement is about, but this is only.
Please also read, my lord, somewhere in the center, about 10 lines above 432.
Did he challenge the summons at the first instance?
Yes. I was reading that about 10, 12 lines above 432.
Yes.
Lord, I was, may I read that part which begins with the expression to put it differently. Lord, about 12 lines
Yes.
from the bottom of, to put it differently, at the stage of recording of statement for the purpose of inquiring into the relevant facts in connection with the property being proceeds of crime is, in that sense, not an investigation for prosecution as that. And in any case, there would be no formal accusation against the noticee. Such summons can be issued even to witnesses in the inquiry so conducted by the authorized official. However, after further inquiry on the basis of other materials and evidence, the involvement of such person, noticee, is revealed, the authorized officials can certainly proceed against him for his acts of commission or omission. In such a situation, at the stage of issue of summons, the person cannot claim protection under Article 23 of the Constitution. However, if his her statement is recorded after a formal arrest by the ED, then they do. So therefore,
His first summons, he will come, he will ascertain, he will
Yes,
record
yes,
statement.
yes.
You may come to a conclusion, there is nothing
Yes.
against him. You may come
Then
to
I
a
don't
conclusion,
proceed.
Then you will proceed. in
Lord,
court.
there have been multiple instances when we summon only somebody as a witness. We do not proceed against them. We do not know what is the involvement of the person concerned. And the Honorable Supreme Court says, if we find some material, then we can proceed. So at this stage, my lord, the writ petitioner is either thinking that he is guilty or he is unnecessarily doubting that he would be proceeded against. If the writ petitioner contends that he is clean, he should grab this opportunity, come to me and say, look here, take my bank account. See, look into all my bank statements. I'm a clean person. Every property that I have purchased is in accordance with tax paid money. What is his difficulty? All that I have done is welcomed him to my office to record his statement and to see how he has earned money and what property he has purchased. If that, my lord, if I cannot do, then, my lord, there is no point in allowing PMLA to exist on the statute book. Then, my lord, coming back to my proposition, the fourth proposition, my lord, my learned friend had argued that the stay of proceedings under the PC Act will come in the way. My respectful submission, my lord, that why stay? Even if it is quashed, it will not come in the way. Even assuming he succeeds in getting his quashed, that does not prevent me from proceeding, because he may not have made disproportionate assets for the purpose of the PC Act. But if he has assisted in generating the proceeds of crime, he has still committed independent offense under Section 3 of the PMLA. So getting a clean sheet under the PC Act is no guarantee that I cannot proceed him under if I am able to demonstrate before your lordships that he has committed an offense under Section 3. So therefore, that would not help him at all. Then, my lord, my learned friend also referred to the fact that there was a joint hearing and that has caused some amount of prejudice. I would submit that the joint hearing took place at the behest of the writ petitioner himself. He said, in his writ petition, he said, there is one more petition in which the predicate offense is challenged and stay is obtained. Right? He was the one who said that in the other case, there is a predicate offense committed, the accused therein, they have obtained stay. So he said, give me a benefit of that. So it is because of that, then the learned single judge said, all right, you are now saying, because there is a stay, you want me to stay, why don't I hear everything together? So learned single judge was right, and it was done with the active consent of all parties involved. So therefore, now the writ petitioner cannot turn back and say that the joint hearing has caused me any prejudice.
Not active consent. This was a point actually argued before the learned single judge. Put it in writing in the written arguments.
There is nothing, my lord. The order does not disclose any such thing. Finally, my lord, my respectful submission is that the writ petition is not maintainable for on two grounds. I would say rather on 3 grounds. Number one, my lord, I am relying upon the Kunisetti judgment. I think we have read out, my lord, I have already produced it. In Kunisetti, my lord, the issue was whether a show cause notice or a charge sheet can be challenged.
The part of this.
It is there. I will just read one para in Kunisetti.
Synopsis.
In the synopsis I have referred to, but that one para, my lord, if I may read, in Kunisetti, it is there in my compilation. There, my lord, their lordship said that one cannot challenge a show cause notice.
That's the context of departmental.
True, my lord, no. The principle laid down there is A show cause notice is not an adverse order. It is only an allegation that you have breached those own law. But here, my case is one step ahead. I have not made an allegation that you have committed on offense under section 3. I only said, please come. So therefore, my respectful submission, there is no cause of action. To approach your lordships, there should be a cause of action. Unless there is an adverse order, there is no cause of action. Number 2, I would say there is no legal right. At this stage, there is no legal right for the writ petitioner to approach your lordships. For that, I am relying upon the Raghav Bail judgment of Honorable Delhi High Court. And finally, my lord, that I stick to my original argument that the writ petitioner having chosen to invoke the 482 roster, now cannot go back and say that 2 things. My lord, last time, my lord, when I pointed out that the 482 roster has been invoked, my learned friend said that at that point of time, everybody thought that ECIR and FIR are one and the same. But then, my lord, later when I corrected that, much before that, the
judge has gone to the merits also.
he has gone to the merits. But then, my lord, why? I mean, the learned judge can go on merits even under 482.
Yeah. You are saying context in the context of the maintainability of the appeal.
No, yes, because if it is a 482, if the learned judge had exercised 482 coupled with 226, then, my lord, no writ appeal lies under section 4 of the Karnataka High Court Act. Then his only remedy is.
But it was a petition under 226 also 226.
Yes, it may be 226 also. But the moment it is.
CT Ravi, on 226 also 482. Yes, have that look on that.
Lord, I look at
Just
it.
a very, I think possibly just before.
I look at it. I look into that. There is a. I look into it. I'm not till she searches. But I look into that. There is a last year, a honorable division bench of the Honorable Madras High Court, not held in one case, that the moment a ECIR is registered, it breaks the umbilical cord. That is what their lordships say. It becomes a completely independent offense. And their lordships then go to say, a stay of the predicate offense will not come in the way of proceedings under the PMLA. Not I'll furnish that judgment. I'll furnish it. My lord, later I will hand over, my lord.
Yes, Mr. Patil. Please. How much? 5 minutes. We spend a lot of time on this. Oh, 50. Take it till 2 o'clock, 1 o'clock.
Please. Kindly go to annexure H, page 367. In respect of this very predicate offense, an FIR was registered against the appellant for offenses punishable. That would be page 371 bottom. Punishable under section 120B, 168, 200, 403, 405, 409, 418, 419, 420, 424, 425, 427, 467, 468, and 474. Read with section 34 IPC, alleging registering a predicate offense against the present appellant. This is quashed. First time, they made me an accused in the case of predicate offense. Authorities said we don't have material to continue proceedings against him. They dropped it. Then accusation was continued. They charged me under 409 and 202. Therefore, it is not a case of a predicate offense independently being there. I am somehow might have been connected with the that predicate offense generation of that money. This is a case wherein, in respect of predicate offense, time and again they tried to implicate me, and it is quashed. If it is quashed, my lord, as said in Vijay Madan Lal Chaudhary, para 231 to 255 and para 283. They cannot step in. I will highlight the word. Kindly take para 283, my lord. Even though 2002 Act is a complete code in itself, it is only in respect of matters connected with offense of money laundering, and for that, existence of proceeds of crime within the meaning of section so and so is quintessential. Absent the existence of proceeds of crime as aforesaid, the authorities under the 2002 Act cannot step in or initiate any prosecution in respect of this particular predicate offense in which they say the proceeds of crime are generated. If I was an accused and I am acquitted, or proceedings are quashed against me, that specifically it is said, as far as that person is concerned, you cannot continue.
May take your lordship's leave, my lord.
Kindly go to para 250 in that judgment. 250, my lord. Of course, I have read it thrice. I'll only point out those. Kindly go to page 253. Yes. Tersely put, it is only such property which is derived or obtained directly or indirectly as a result of criminal activity relating to schedule offense can be regarded as proceeds of crime. The authorities under the 2002 Act cannot resort to action against any person for money laundering on an assumption that the property recovered by them must be proceeds of crime and that a schedule offense has been committed unless the same is registered with the jurisdictional police or pending inquiry by way of complaint before the competent forum. For expression derived obtained is indicative of criminal activity relating to a schedule offense already accomplished. Similarly, in the event the person named in the criminal activity relating to schedule offense is finally absolved by a court of competent jurisdiction, owing to an order of discharge, acquittal, or because of quashing of the criminal case, schedule offense, against him or her, there can be no action for money laundering against such a person or person claiming through him in relation to the property linked to the stated schedule offense. Now, my learned friend is categorical in saying, in crime number so and so, in the bank, it was found that such and such an amount, 62 crores, is misappropriated. Again, a schedule offense case is registered and matter is pending. It is in respect of that very offense, that very criminal activity, I was arraigned as an accused. And after investigation, first time they said they don't find any material against me and they dropped me from charge sheet. Then under 173(8), further investigation was done. Still they said no schedule offense against me. That is one part of it. Independently, in respect of same offense, they registered case against me, alleging offense under the predicated offense, schedule offenses also. That is quashed by this honorable court in the earlier writ petition. Therefore, this is a case wherein I am discharged. I am in the proceedings against me in respect of this, in respect of the schedule offense in which the proceeds of crime is generated is quashed in respect of me. Therefore, I come under every one of those categories under 253 for the proceeds of crime generated out of that particular schedule offense. Nothing can be done as far as the petitioner is concerned by PMLA authorities. That takes it. Please.
What is being contended is, you may not be part of the predicated offense.
Please.
But to know the trace within the scope of those three, they can call any person.
They can call any person.
The argument.
Yes.
What do you say?
For that, my lord, that in fact, your lordships actually put that question to my learned friend. I would say he did not choose to answer except pointing out a hypothetical situation. Kindly go to page 91, the summons issued to me. This is not a summons issued for asking or finding out who else is involved, where did the money go. Kindly see page 91, specifically. Details of all immovable properties held in your name and in the name of your family member. Details of all bank accounts and movable properties held in your name and in the name of your family members. Copies of ITRs filed by you from the last 15 years along with the annexures. Now, there is no question of their tracing the money where it went. They are saying, yes, ECIR, your name. In that, we want to have the material. In respect of a proceeds of crime in a schedule offense in which I was an accused and I am acquitted. Therefore, my submission is, in respect of the proceeds of crime out of that schedule offense, they cannot step in as against me, even for the purpose of this thing, because this is not gathering information. This is actually investigating, asking me to file my income tax returns, asking me to give the accounts of my property.
What is being contended is section 3 is making summons issued to come to a conclusion where is the trace of the money. That's all.
That's true. For that itself, the words used in para 253 is something. It's by 3-judge bench, my lord, as your lordships have noticed. All the other 3 judgments that were placed reliance are by 2-judge bench. Here, kindly see, they cannot escape these wordings. Tersely put, it is only such property which is derived, obtained directly or indirectly as a result of criminal activity relating to a schedule offense can be regarded as proceeds of crime. The authorities under 2002 Act cannot resort to action against any person for money laundering on an assumption that the property recovered by them must be proceeds of crime and that a schedule offense has been committed unless the same is registered with the jurisdictional police or pending inquiry by way of complaint before the competent forum. For the expression derived or obtained is indicative of criminal activity relating to a schedule offense already accomplished. Similarly, in the event the person named in the criminal activity relating to the schedule offense is finally absolved by a court of competent jurisdiction owing to an order of discharge, acquittal, or because of quashing of the criminal case against him or her, there can be no action for money laundering against such a person or person claiming through him in relation to the property linked to the stated schedule offense. Therefore, your lordships put a question to my learned friend saying, purport of this observation is, if as now stated by my learned friend, the proceeds of crime are generated in respect of a particular schedule offense, so and so registered. An allegation of embezzlement of funds of more than 63 crores, etc., etc. In respect of that offense, I am charged of offenses which are also scheduled offense under the PMLA Act. That is quashed against me under Annexure H, one aspect. In another, during the registration of this crime, I was also arraigned as an accused. Specifically, they said material is not available to charge this person. They dropped it. Then later, they took up further investigation. In further investigation, they specifically found no offense of schedule offense against me. In Pavanadipur case, it is specifically pointed out 120B is not a independent offense. If 120B is used in respect of some offense which are not schedule offense, then also PMLA will not come into picture. Therefore, in this case, schedule offense, it was found that I am not involved in the schedule offense. Discharged. Against me, they have registered now a case which are not schedule offense. Therefore, to get over this paragraph, to say that I want to record statement, therefore I placed before your lordships summons issued to other persons. There they specifically say, we want to record your statement. Here, they have registered the case. And of course, that was one thing I wanted to make it clear when my learned friend was present. They have presented that written synopsis on 15th, on which date matter was reserved for this thing. That is why I made a submission, and I'm sure I was correct in saying it was nothing was placed in writing till the arguments were over. They went on saying there is one case which is stayed. There is another case which is not stayed. Therefore, in respect of the case for which my learned friend now says I am being asked, I would say I am covered under the eventualities pointed out under para 253, and therefore they cannot step in, would be the first thing. Then your lordships put a question to my learned friend. There is a case pending under 13 of the PC Act, whether it is that for which the person is summoned or any investigation inquiry is being done, because that case is stayed. For that, my learned friend said, or rather, he did not directly answer that it is this thing. So we may take that it is not that schedule offense which they are pursuing. Therefore, at this stage, I would respectfully submit, in respect of the schedule offense for which he wants saying you were the chairman, therefore you must be knowing this, that, etc. None of those things would reflect in the summons. On the other hand, summons reflects that there is a case registered against me, though it is not called as FIR. Therefore, it is not permissible. Cannot be equated to a show cause notice.
Are you saying that once that criminal case has been passed? Or
Yes.
charged for a predicated offense?
For a predicated offense.
Proceed under section.
They cannot proceed against me in respect of section 3 because I am not involved in any way with.
Stage has come.
That stage, as far as petitioner is concerned, it has come because it is quashed as against me.
Right. It is only for the purpose of maybe investigation, maybe recording a statement. But that stage that now under 3 you are being proceeded.
That's why I said, my lord, kindly in 253, they make a different case in respect of the persons against whom they started investigation for generation of proceeds of crime. In respect of that, they say, if we are acquitted, if you are discharged, if it is quashed.
Discharge, acquittal, or quashed.
Quashed. In this case, I was an accused in that.
And against him, there can be no action for money laundering. Against
Money laundering. That is why I here, that's the first this thing. As regards the second aspect, if they are making the inquiry, investigation, etc., in respect of the predicate offense under 13E of the PC Act, then my respectful submission is that stage has not come. They will have to wait. There is an interim order of stay.
Yes, Mr. Deshpande. That's all, Mr. Patil.
Please, my lord. And that prejudice, as far as they are putting it in writing, it was on the date of matter being reserved for judgment. Nothing was put in writing because I may be asked, you are not raised this ground, you are not raised that, or you are not this thing, because that was none of that was disclosed. First thing. Second thing is, my lord, this prejudice argument was full-fledged advanced. It is put in the written argument submitted by the appellants in the writ petition. I will place that.
Also submitted the submissions.
Yes.
Before, after they have submitted.
Yes.
Where are those submissions?
The written submissions, I will, with a memo, it is given, I think.
Mr. Deshpande, what Mr. Patil has argued is this. He says the offense under which, that 409, he has been discharged or he has not been proceeded. No, the FIR qua him stands. But to the extent of 409 only and one red bit 120B. That's it?
No, not 120B, 36.
So these are the two, which is not a predicated offense. In that eventuality, discharge, it's as good as a discharge under the predicated offense, then they can't, for the purpose of PMLA, he can't be proceeded.
They tried the second method of putting the same again by another FIR, which is quashioned under Annexure H.
Okay. Which is that FIR?
Please, my lord. That is FIR number
235 of 2014.
Page 400, my lord.
Crime number?
FIR number 16 of 2021 could not have been registered for the offenses under IPC, and it is quashed. It starts at page 360. FIR number 16 of 2021.
Which is the page and where is this conclusion? Where is the conclusion?
Please, my lord. Annexure H, page 367, it starts, my lord.
This is the order of the court.
Yes, my lord, this honorable court, I challenged it in the,
Which is this 235, 2014? FIR.
that is, my lord. That starts at page. May I give you this? Kindly see annexure C, page 95, first charge sheet, wherein it is dropped against me. That would be page 112.
Since you are saying up to 35.
235. 17/7/2014, page 112, bottom, it says it is dropped. Of course, my lord, I will give the translated copy, I'm sorry.
I'll have my lunch here and then.
Yes.
One second.
Then the second FIR, 325 of 2014, annexure G, page 226.
Which page?
It starts at page 226.
Yes.
Charge sheet, page 235, pertaining to the appellant. Page 235. Offense alleged is 409-202, read with 36.
What happened to this FIR?
This is not FIR. The proceedings. In the earlier proceedings itself, this is filed as a final charge sheet.
It's pending.
Now it's pending. In CC number 2776 of 2019.
So
No, it would be the.
what do you say on this? Now, what has been set aside? 409-202, that is continuing. That is relatable to the second FIR.
Second FIR.
235.
230.
Now, the first 16 of 2021 has been set aside.
I did not get the question, my lord, your lordship.
So what? Which has been quashed?
FIR 16 of 21.
Has been quashed.
Quashed.
235, you are not being charged.
I have not been charged. And at a later stage, in that continuation of investigation, in that 235 itself, they have brought it to 409 and 202.
This 2000, under section 13 is which FIR?
That is. I've given the copy of the interim order. I will just point out that.
Mr. Deshpande is being said is. 16 having been set aside. Right, aligned upon this 253 paragraph.
Yes.
They'll also agree.
Yes.
There cannot be any case action under the MLA, PMLA. That's in substance is the same. What do you have to say?
Lord, our submission is that, my lord, the existence of schedule offense. If the schedule offense is in existence, we can proceed against the persons who are involved in the money laundering. So the existence of schedule offense is not in dispute. Original FIR, that is annexure C, my lord,
What is the number?
325 of 2014, my lord. 325 of 2014.
Under section 13 of the Corruption Act.
No, my lord. It is under section 409, 465, 468, 471, 201, 120.
Your lordship's
Read with
referred
section
as 235, it's actually 325.
325.
325. It is
325
not
of 2014,
This is that 409.
409, 465, 468, 471, 201, 120B.
But
Right?
against you, it is under 409 and
202.
202.
I am not bifurcating the schedule offense as against the,
Right.
yes. Yes, ma'am.
What you're saying? You
Yes,
say
ma'am.
there is a schedule offense.
Yes,
Which is 325-14.
yes, ma'am.
So why he is concerned,
Yes,
he
ma'am.
may not be part of the schedule offense, but he is part of that FIR.
Yes.
To the extent of 409-202.
That is his contention. Even if he is not an accused, even if he is not an accused, if there is a schedule offense and that particular schedule of,
There is a schedule offense, even if he is not an accused.
yes, ma'am. In my situation, my lord, he is an accused, but as against him, the charge sheet is he is not charged under section 471. Yes.
See the schedule offense,
471, my lord.
421.
471, my lord.
471.
Not 409.
No, not 40. 471, my lord.
ये केस नहीं है
Mr.
कर्नाटका का केस
Just give your note of submission by
Please.
tomorrow morning.
No,
Will you give it
Friday would it be?
this Friday?
I get one more day,
Okay, give it Friday.
please.
We'll reserve it.
Yes, madam. There is one judgment I will serve advance
Give
copy.
it to him.
Yes, madam. Madras High Court Division Bench judgment.
Just say this, we have heard the counsel for the parties. Just say that Mr. Arvind Kamath, learned ASU, has filed the
Synopsis of argument.
note of submissions.
Yes, ma'am.
Which is taken on record.
Additional list of authority.
This additionally, it is taken on record. This Pavana, this rule, you filed it on the last day.
Today I have filed it. Today.
The date is of 31/2025.
Sorry, my lord. I should have mentioned. I had prepared. Yes, ma'am.
He has also filed a judgment of the Supreme Court in the case of so and so. Mr. Patil shall file his submissions by Friday.
Please.
Orders reserved, interim order if any to continue till the pronouncement.
Will.
We'll take this. Next.
That is paying for the appellants. Yes, there are office notes with regard to non-furnish of the PF matters. Since respondent number 1 has appeared, office notes may not survive for consideration. 1, 2, and 3.
What has happened?
Matters prayer to set aside the order.
No, there is a delay needs to be condoned, my lord, because there is a gap of about 5 years from the date that orders have been passed. They have come after 5 years before this court. I have filed, unfortunately, I have not filed the wakalat, but filed the objections. I'll file the objections. I will file the wakalat in the registry today. And I also filed objections to the condonation delay. My lords may take it up next time.
The issue is before respondent number 2, the proceedings are going on against respondent under the Public Premises Unauthorized Occupants Eviction Act 1971. He had filed 2 applications summoning certain documents. We had also sought under the RTI minutes. And the RTI, they did not look at the document. They said it's more than 20-year-old, it's exempted. Then what happened was that applications were rejected. He challenged before learned single judge. Learned single judge held that you did not say that in the RTI information reply that no such documents exist. But you simply said that more than 20 years, you have no impediment for producing before the respondent number to the estate officer. They made a correspondence since of the year 1971, what he said. No copies were made. He simply says that you have issued the notice in the year 1971 also in respect of the very same property against him. He did not produce any document, but he simply refers to some notice number. That's all. We inquired and found that no such documents exist. So this is coming in a way. No, we don't. We maintain the registers of all the.
They may have to explain the delay at the first
This
instance.
delay caused months minutes. Advice was taken. If this order is left to stand, it will be coming in way of other proceedings before the estate officer. In that context, opinion was taken and this has been filed. That is how the delay is occurred. That is, other than that, there is no much issue.
Number of judgments of the apex court so far regarding the delay caused by they are the functionaries of the state. And the nature of explanation that they ordered is delay in coming before my lords. From the order of the learned single judge is 2019, and they have approached this honorable court in 2024. I have a couple of judgments which I'll cite in the next statement. So 5 long years.
Want to challenge what the delay on their approaching this court?
Yes, madam. Yeah, now 5 long years.
And he had filed one more writ petition, 5793, that has been disposed of. And in that also we have stated, so this how it is there. It is in a narrow compass. He is the one who is filing an application. According to us, we don't have such documents. But learned single judge held against us, saying that under the RTI reply, you did not say that no such document exists, because different officers have given the information. We culled out all the information from all the divisions who is responsible to hold it. Then we came to know that no such documents exist. That's what we have given endorsement. That's what we have put it. That's why he says that a delay from 19 to 2024.
Are you seeking that information from them?
Yes, my lord. I sought that information. They did not give the information on the premise that you have approached after 20 years. That's why we can't give you. Therefore, the learned single judge held that. Is you have at earlier point in time, you did not say that you don't have the documents.
Let's assume for a moment what they have said is not correct. Suppose the document doesn't exist.
That was not their contention.
Right. Let's assume as a fact.
Adverse inference will have to be drawn because I can't be vexed twice.
That's all.
That's all.
So then why should we have continued?
I'll make my submission of the delay.
So if they have not produced, whatever is the worth, adverse inference.
And
the estate officer will presume. Proceed.
And apart from that,
And
Stage in the proceeding.
it is now posted for 28th for my cross-examination. And they need to cross-examine me.
and this matter is going on since 2010. Marat.
No, it is for the second round of litigation. Because I have set up a title in myself. In fact, the estate operator does not have any jurisdiction at all. That's besides the point, because Supreme Court is very clear. Because it is not that I was a tenant, I was indicted as a tenant. I was a purchaser from a grantee. And they say that they are the owner. I also say that I am the owner. Wakalat.
File response to the condonation.
A condonation I have
filed,
filed.
but only-
What has happened is I have filed objections without filing wakalat. Wakalat is here.
File wakalat within 2 weeks from today. We will file the appeal for hearing.
Maybe posted for hearing and IS minutes because the office note it's in the orders list. That does not swear to consideration. That's 1, 2, 3. All the 3 does not serve consideration. Maybe posted for hearing and IS.
The IS. He'll along with the IS.
24/3,
Yavat madam?
24th of March, sir.
Okay. Great.
Serial number 20. Government advocate 20.
Appeal by state, my lord. It has come on process, my lord.
R1 is a private respondent, will take steps, my lord. Insofar as R2 is concerned, my lord, it is planning authority. Your lordships may kindly permit state to serve on the panel advocate Yogesh D. Nayak, my lord.
But
R1 will take steps.
they say that they issue notice to respondent number 1 and respondent number 2 is?
Yogesh D. Nayak, my lord, he appears for the planning authority.
The respondent number 2 to the panel advocate. This is satellite town planning.
He appears for
Through the standing
STRR.
counsel for the respondent to authority. Okay.
Obliged.
Returnable on.
Applications, my lord, additional document.
4/6,
Obliged.
21, 14%.
For our 3 millions, respondent number 3 in this matter. Notes, the question is regarding the maintainability of the writ appeal minutes. Challenge the quashing of FIR, which was dismissed by the learned
Appear for whom?
respondent number 3, the complainant.
The complainant, very well. What do you say?
My submission would be that writ appeal itself is not maintainable minutes.
Ground?
On the intra-court appeals are not maintainable. I'm also relying on the 3 judgments minutes.
Which are those?
One is Ram Kishan Fauji versus State of Haryana.
We'll hear it after lunch. You ready?
Please, minutes.
We'll hear you after lunch. He's raising the issue of maintainability. We have kept that open. Lunch. after
Please,
lunch.
minutes.
Let's keep those two matters.
22. Serial number 22.
First respondent, please. So this, some of the respondents are not served, but the contesting respondent is before the court. I'm the appellant.
But what about the unserved respondent, Mr. November?
Lord, we have taken steps to some of them, Lord. 2 of them are shown as dead,
The 6, 7 are yet to be served.
2 and 5. For respondents 10 to 15, we have paid process fee second time. And 17 is the key person, Lord, who is my vendor. To him also not process has been paid. Respondent 18 has been ordered to be deleted, Lord. Before the executing court. In the executing court itself, BBMP.
No notice to 18?
No. 18 has been ordered to be deleted by the executing court. They made the BBMP a party, which was not a party to the decree.
As was deleted by before the court below.
Yes, ma'am.
On sheet is there. On the sheet.
What about 20?
20, my lord, is shown as not claimed. So maybe could be treated as,
Not claimed here.
yes.
No, it says since unserved cover returned with postal Shara has not claimed.
Not claimed. So that means notification has gone to him, but he has not chosen to claim.
Not unclaimed. Not claimed.
Not claimed.
So then what about the others? So 10 to 15 and 17 you insert.
Yes, ma'am. My lord, I appear for the respondent number 1, who's the contesting respondent. I am the plaintiff in the suit. Suit has been decreed and I have been declared as the owner of the scheduled property. And my humble submission would be that the other respondents, for the limited purpose of my lords kindly considering my application to vacate the interim order at this point of time may not serve the purpose. The appellant is a person who is claiming through a sale deed under a defendant pending the suit. During the pendency of the suit, defendant number 16 has purportedly sold the scheduled property to the appellant. This honorable court and also the honorable Supreme Court has said that the person who is claiming through a defendant or judgment debtor is not entitled to any larger inquiry under Order 21, Rule 97.
Yes.
And therefore, my humble submission would be that my lords may hear me on this application and the interim order, because I have filed execution. in the execution, delivery warrant was issued, at which point of time the appellant filed this application. And the learned trial court on this very ground has held that you are a transferee pendent lite. You are bound by the decree. Provisions of section 52 apply. And therefore, no elaborate inquiry is required, and it is a admitted fact that you are a pendent lite transfer, and his application was dismissed. And that is why the appellant before my lords.
Your submission on that.
My lord, my contention, my lord, is this. In this case, my lord, this property, my lord, was sold, and I am in possession of the property. There's a registered deed in my favor, my lord, on 6/3/2013.
Please agree. That was during the pendency of the suit. What
True,
right to
but
that
the
suit?
Honorable Supreme Court, my lord, has said that if a person is in settled possession without making him a party, my lord, what has happened is in 2013, I buy this property. There's a house in it. I'm living there. All the municipal records, everything is in my name, municipal tax. They don't make me a party. My vendor, my lord, colludes with them. He doesn't give evidence, doesn't give no written statement filed, no contest, no cross.
It is his case that, look here, now I have sold it, I am out.
I'm out.
Correct. That's the
None of-
reason.
none of them really
That's the
contested.
reason why, my lord, Honorable Supreme Court has said that in a case of this kind, when somebody is in settled, not here is a case, the prayer in the suit is for a decree granting possession. So the plaintiff, my lord, claims to be the owner, admits that he is not in possession. Somebody else, according to him, defendant number 16 is in possession. But defendant 16 is sold and I am in possession. And not now, but from 2013. They are aware of it. They don't make me a party. And this collusive decree is obtained against the property, where my case is that I am in settled possession and I have a right to defend.
Was the suit filed?
Lord, suit is filed on 16/11/2012. It is certainly not a
Much before.
much before.
Yeah, before.
So you came in the position.
Yes,
Yes.
yes, that's true. But the thing is, there is a registered deed, and they have challenged, my lord, several other deeds in regard to other properties in the same suit belonging.
Summons issued
Summons was issued immediately, ma'am.
that.
The order sheet they have filed. My lord, suit was filed, not much.
3 months after the suit was filed, is this
No, what is the date of the sale deed in your favor?
6/3/2013, ma'am.
Was the summons issued in the?
My
your
lord,
suit?
suit summons was issued.
Order sheet,
They
execution order
filed
sheet
the
was
order sheet of the entire suit.
But you had the knowledge when you.
My lord, I had no knowledge about any transfer, my lords, because
Vendor who has sold it to him.
they'll have knowledge of it.
No. No. He may be having, we want to know whether summons was served on him.
On defendant number 16, his vendor, yes, please, they were all placed ex parte.
The summons was. served
Summons have been served.
Before this transaction.
yeah,
took place.
Before this transaction took place, that is a date that I will have to check, my lords, that I will have to check. But nonetheless,
16 is
I am also claiming under a sale deed of 1995, my lord. What has happened, my lords, here is respondents number 1 to 8 were the original landowners. They granted a general power of attorney to respondents number 9 and 10. Under the general power of attorney, these 9 and 10 formed a layout in this area, and they sold me 3 sites, 74, 75, and 76 under a sale deed of 3139.
Effectively between both of you litigation. Or others are also would come in.
No, so far there are others. One other defendant is also filed. Not that other defendant, I understand, has filed a suit challenging the decree in the suit itself.
Oh.
Yes,
What happened?
in an
to that
RFA.
suit?
I'm told that is pending. No, I'm not appearing in that, but this is information we have. That one other person, my lord, there were 3 sites here, my lord. In regard to one site, decree was not granted. That was site was dismissed as number 75. 74 and 76 which have been decreed. I am in 76. The owner of 74 has challenged it separately. That is pending.
Suppose he succeeds.
Yes, he succeeds, the decree will have to go. My lord, my submission is, my lord, ultimately, my lord, while I generally, my lord, the proposition that a pendente like transferee claiming through a defendant has no independent right. But, my lord, the facts of the case are these, that in this case, the decree is granted against my vendor and he doesn't contest the suit. He doesn't file written statement. And the Supreme Court, my lord, in 2 or 3 decisions that I have them have laid down that if somebody is in possession, his presence.
Party?
The one who sold to me is defendant 16.
No, how are you made a party? in
I'm
the
not
suit?
made a party. What happens, my lord, is the decree is made, they filed execution proceeding.
Then only.
In the execution proceeding also, I am not made a party. They took a delivery warrant and the court, my lord, issues delivery warrant. And on the same day, my lord, they ask the court for police protection and the court grants police protection. Against that, at that stage only I come to know this.
My lord, defendant number 16 in the suit has been represented. my
There is
lord.
an objector application that I have filed, my lord. The court says no inquiry is needed on that. That's plainly contrary to, my lord, the law of the division bench of this court in Paramount Industries. If somebody claims, whatever may be the nature of his claim, whatever may be the nature of his possessory right, that has to be inquired in. The court cannot say,
Now tell us something, you want these to be served, 10 to 15 and 17?
yes, my lord, I think they should be served, my lord. I'll file objections to his application also. Meanwhile, my lord, I'll find out the other appeal number. If it arises from this very same proceeding, we'll furnish that number, my lord, and maybe that will have to be listed before your lordships only.
They say respondent 10 to 15. So file an application or so.
Yes,
You want, we
Yeah.
don't know which year is that RFA.
I'll get the details, my lord, and make.
I have not received any notice of any RFA filed by the person who's claiming the site number 74. I have filed a separate RFA, my lord.
10 to 15 and 17. Mr. Colonel and a senior counsel appealing for the appellant states that no notice is required to be sent to respondent number 18 as he said respondent was deleted before the court began. So far as respondent 20 is concerned, the registry's report is, the service report is not claimed. That this was service on respondent number 20 is deemed to have been effected. It's stop. Now what?
Other respondents, but that is 10 to
15 and
15.
17. That we have issued notice.
Yes.
Returnable.
My lord, they may, in my humble submission, may not be required for this honorable court to consider the objections that they are.
Ultimately, you are the only.
I'm the only contesting party.
Then we could have, but what Mr. Narayan says, is notice be issued to them. The point. Just give it in March, April first week. First week.
Interim order may be extended.
Interim order you can do.
But meanwhile, I have, my lord, started a dialogue to see if there's some via media that we can arrive at. Because they are claiming to be prior owners, yes. And I am claiming to be subsequent owner, my lord. In case before the next date, if you are able to reach some amicable settlement, my lord, we'll not trouble your lordships.
Very well, thank you.
Grateful.
My lordship, I want to mention item 50. It's the
Madam, 230 mention, madam.
Yeah, someone. Yeah, I'll be mentioning it, I think. It's 23 right now. Mhm.
Serial number 15 passed over matter. Appearing for the appellant. I have informed my client about memo, intimated about retirement from the case. On 7th, I have already forwarded the necessary papers along with no objection wakalat. So if one more date is given, my lord, I will intimate and they'll make alternative arrangement. I am for the appellant. Mr. Srikanth appears for the respondent. It is passed over. Serial number 15. Whatever date convenient. So that I will intimate my client also.
You are for the.
I am for the appellant. V.S. Naik, I am for the appellant. On 7th, I have sent all the papers, requesting my client to make alternative arrangement.
The society is.
Yes, yes, ma'am. Yes, ma'am.
Other matters also of this. Just the journey.
24-3.
24th.
Was for a shorter date. Mention is not settled because of the penalty of litigation.
Next.
Serial number 34 minutes. 34 for the appellants.
Yes.
Respondents has filed statement of objections, minutes. We need to file rejoinder to that objection. I have informed the respondent, minutes. Once the respondent is present before this court.
This is
34 minutes.
Who appears? You are for the appellant.
Minutes.
The request for the learner counsel for the appellant states that he intends to file rejoinder to the objections filed by the respondent. This is MSA 12.
12 minutes, please.
We file within 6 weeks, adjourn to.
21-4.
The lordships kindly notes, serial number 28 minutes. The parties are looking for an amicable settlement. A learned friend is here. It can be.
For the party states that the parties are exploring a settlement. This is MSR Hotel.
Yes, ma'am. Yes, ma'am.
That they request adjourn to.
Yes.
24-4.
Okay.
Twenty-three. The last portion.
Here for the appellant.
Yes.
Appellant's land on extent of 5,160 square feet came to be acquired by the National Highway Authority for widening the National Highway of 48 your lordship. And the award was passed. Dissatisfied with, I preferred an appeal or a petition before the Deputy Commissioner and your lordship. He heard the matter. He did not give a date when the order will be pronounced. That your lordship gets it at page 48, your lordship. And your lordship, he simply posted after hearing the matter, posted for orders. He did not give a date when the order going to be passed. He passed the order on 22/12/2023. That your lordship, we came to know on 10/1/2024. On the very same day, I applied for a certified copy. We received on 4/3/2024. And the petition.
Who has passed this order?
District judge.
Who has passed
District
this
judge, your lordship.
order? But what did district judge say?
He says I have filed in my petition is barred by limitation, your lordship.
When did you challenge the arbitrator's award?
I immediately, your lordship, I obtained a copy on 4/3/2024 and 25/9/5/2024. I have filed the appeal before district judge. That is within the period of 90 days plus 30 days, 3 months, your lordship, as provided by section 34(5),
Receive the copy of the award.
10/1/2024, your lordship. Copy was received on 4/3/2024. I applied for the copy on 10/1/2024. The day I came to know the order has been passed, your lordship.
The arbitrator.
Yes, by the arbitrator, because your lordship, I brought your lordship. Arbitrator heard the arguments, received the written argument produced, posted for orders. He did not specify when the orders will be passed. Subsequently, on 22/12/2023, the order is passed. Law requires that I should be communicated, your lordship, by a copy. Even that was not done by him. Therefore, Your Lordship, on 10/1/2024, I inquired and came to know the order.
Was the award passed? What was the date of the award?
22/12/2023. Yes, Your Lordship.
30th of June 22.
No, Your Lordship. May I bring to Your Lordship consideration, page 49, the order sheet I have produced.
You filed the petition under 34.
Yes, Your Lordship. 29, I filed a petition before the 29th March. I have filed, Your Lordship.
See, the dates are not matching. Come to page 18.
Yes, my lord.
He says,
Yes, I understand. It is pertinent to note that in the above citation, arbitral tribunal has passed an award on 36/2022.
right,
My lord, this is the learned judge is referring to the judgments which he is referring, not in our case.
okay. Yes, you are right. Now let's see your facts.
Yes, your lordship. I brought your lordship the.
Passed on 22/12/23.
Yes, your.
Not communicated.
Yes, your lordship.
We copy on 10/1, he had approached the respondent, but he inquired about the proceeding. Passing of the award, immediately apply for certified copy on 4/3/2024. Now, period between 10/1/24 and 4/3/24.
Yes, your lordship.
Shall be counted for limitation.
Yes, your lordship. Even that is taken into account. My appeal is filed on 29/5/2024. That will be within a period of 90 days, your lordship. From the date of receipt of the copy, 4/3/24.
Section or from the date of receipt of award.
The section is very clear on the point, your lordship. Not from the date of the pronouncement of order, but when I receive the copy, may I read that, your lordship. An application for setting aside may not be made after 3 months, have elapsed from the date on which the party making that application had received the arbitral award. In fact, district judge, learned district judge has passed the order without issuing a notice to the respondents. Yes, ma'am.
4/6.
Much obliged.
24, serial number 24.
Effectively for the appellant, my lord. Lord, there was a small discrepancy, my lord, committed by the registry of the trial court. Lord, only at ink page 11, the date of the suit is mentioned at 13/1/2023, my lord. Correct date is, my lord, at ink page 14 and decree sheet also at 33, my lord, ink page 33. Lord, and your lordship directed me to make an application for correction before the trial court. That is done, my lord, by my client, and the orders are yet to be passed. That application is not taken. Suit number, my lord, is initially is 16/2016. I'm having the certified copy of the plaint, renumbered as OS 30/2023. My lord. So in that event, suit having been filed of the year 2016, we have to add, my lord, while in 2025 appeal, my lord, 9 years to each parties. So
30, page 11.
Page 11, my lord, it is 13/1/2023. Your lordships are right. Page 14 may kindly be perused, my lord. Page 14. Date of institution of the suit, 18/1/2006.
We have given the number.
Yes,
Suit number is 30 of 2023.
three.
It's a new number given.
Yes, new number given. And decree sheet also, your lordship may peruse. Ink page 33, my lord. It is presented on 12/1/2016, registered on 18/1/2016. So only at one page, my lord, at ink page 11, that is first cost title, first page of the cost title of the judgment.
Order from the district court.
My lord, application is made by my client.
An order.
No. Orders are yet to be passed because my lord, for FDP now the suit is disposed of and our client has engaged some other advocate for filing FDP. So there was some delay, my lord, and now as of now, my lord, application is filed. Your lordship may grant us, my lord, some. I will get it corrected at 20th January. Your lordships were pleased to pass an order.
You have both the respondents?
No, R1, my lord, is the power of attorney holder of R2. Respondent 1 is the GP holder of respondent 2.
You appear for one only. Two, you don't appear.
My lord, 1 is also a PA holder of 2, my lord. Lord, it is there in the cost title of the trial court.
Okay, no? Do you appear for two? See. So answer appears for respondent number 1. On a specific query whether we shall appear for respondent number 2 as well as the respondent number 1 is the
General power of attorney holder
PA holder
of R2.
of R2. If the answer is in the negative, that we saw it as effective on 2.
My lord, I have paid process only for respondent number 1, my lord, in his individual capacity as.
To respondent.
Yes, ma'am. I'll do the read.
Interim order to continue till the next date.
Yes.
The order dated 21/25 shall continue till the next date of it.
Yes.
10/6.
Great. Notice to R2.
You have said so.
Great.
25 adjourned, 26.
Show me that. This is none for the appellant. Dismiss even there was no appearance of the appellant on the last date of hearing, that is 21/1/25. Appeal is dismissed for default and non-person. Next.
What else?
27.
What else? Extended.
I pay for the appellant, my lord. On the last date, my lord, on the last date of hearing,
Yes.
your lordship asked me to file additional affidavit. I have filed, my lord. The lordship may kindly condone the delay because that corona has devastated our life, our entire family's life, my lord.
Did you file, Mr. Ram Mohan?
I beg your pardon, my lord.
Did you file the affidavit?
On additional affidavit, I filed it on 31st, my lord.
What is the delay?
142 days.
About?
The 60 days, whatever that is.
Oh.
200 and odd days, my lord, 300 days, my lord. Your lordship may kindly condone this delay, allow me to contest it on merit. I have lost everything. There's nothing much. My
Still appeal, Mr. Rao.
Yes, my lord, yes. In fact, no, I am not due any money. That, of course, on merit, when I argue, your lordship will appreciate my stand. Every aspect of the transaction is in violation of the laws. There is no records at all. The delivery of challenge, he says, my signature is not there. My signature, he admits that there is no signature at all of mine. There is no service, there is no supply of goods at all. Though we have been transacting before, this particular transaction, there was no transaction at all, my lord. He says he has sent the lorry loads. Along with my invoice, they have to file, my lord.
Passed, judgment decree.
Judgment and decree passed by it was passed on 1st July 2022, my lord.
Before, much after.
The corona just ended, my lord. Just ended, my lord. But then the after effects of corona, my lord, I respectfully submit. Even now, people are suffering after effects of corona, my lord. I respectfully. Yes, my lord.
Supreme Court order would not be given. You would not get it.
But I am not on that aspect at all. I am only requesting this honorable court to show some mercy on me so that I can contest it on merit. If I am losing it on merit, fine, there is no problem. But then not on this ground, my lord. Because
Does the law say
limitations, I should file the appeal in time, much before the limitation expires, much before 60 days, my lord. I have not done so because of my problems.
yes? Now, reasoning, you see your reasoning.
I beg your pardon, my lord?
See the reasoning in your additional affidavit.
Yes, my lord. Additional affidavit, my lord.
See,
My lord. My sickness during the month of July and August 2022 was so serious, my family thought that I was dead. I would be dead. Added to that, I suffered corona, fever, and loose motion. Though I was in bed during August, September 2022, I could not resume my normal work because of the after effects of corona. Then my financial position became so bad, I was not able to meet my family's bare minimum expenses, my lord. My business was dull during the entire period of corona, and I could not make any money. Added to this, I had to pay my staff. Whether I make profit or not, my payments to my staff cannot be stopped. I had to borrow a lot of money to clear my payments to my staff and to my suppliers. Since I was burdened with the above problems, I could not meet my advocate as I was out of Bangalore for mobilization of funds, including the court fee. To mobilize the court fee itself, I was struggling, my lord. With much difficulty, I mobilized the court fee and immediately contacted my advocate. I respectfully submit it is for the above reasons and other reasons the delay of 146 days happened. It was not deliberate and intentional. I respectfully pray on the basis of this additional affidavit and the affidavit already filed by me, the delay of 146 days may kindly be condoned. If the delay is not condoned, my family and I would suffer a lot, and we may not be able to come out of the financial strain we may have to face. Therefore, I respectfully pray that this honorable court be pleased to allow that on the basis of this additional affidavit, allow the accompanying application, condone the delay in filing the appeal in the interest of justice, my lord.
where are the documents for your illness?
My lord, corona.
Where are the documents?
For what, my lord?
Illness,
Have you?
illness.
That's what, for corona, I have no documents, my lord, because I never went to the hospital at all. If I go to the hospital, I am in trouble. So, and then the other is vomiting and fever, treated at home only, my lord. There are no,
Was not so grave that you could not have pursued the litigation.
but after effect of the corona, I could not move out, my lord. That is the problem. That is exactly the problem. Even now I am suffering the after effects of corona. Many people are suffering. I am also one of them who is suffering that corona's effect, after effects, my lord. By condoning this delay, I respectfully submit, my lord. No harm is going to be caused to the respondent.
Question of, this is not section 5, Limitation Act.
I
We are in a different jurisdiction.
understand, my lord. Your lordship may kindly condone this delay, allow me to contest this appeal. If I lose on merit, I am okay with that, my lord, but not on this ground, my lord. That's all is my respectful submission to your lordship. Your lordship may kindly show some mercy to this appellant so that he will not be guilty of not fighting this case.
146 days is a huge delay. That's what Supreme Court said.
I know, but we had with this delay, if this court minds it should condone the delay.
Because of the judgment of Supreme Court, no discretion for the court.
It's all right, my lord. I respectfully submit. This court may still come around, show some mercy on me, and give me an opportunity to contest this case. That's all. If this court says, no, we cannot, you have no chance at all, no remedy, I have no choice. I can't even pay the money.
Then you could work it out before the-
That is a different story. Sometimes my position is so bad, I must be given because an opportunity to contest, because the entire case of the respondent is that he has supplied goods against the law. He has actually committed a crime. I brought it to the notice of the trial court, but then the trial court did not appreciate, did not even mention that. That's the whole tragedy in my case, my lord. There is no royalty paid on every invoice. The law says that on every invoice, royalty must be paid, receipt must be attached, and then the invoice must go. Then every lorry, the driver has to be mentioned.
Yes.
Every lorry load, the way bill has to accompany the royalties, etc., etc. If nothing is produced, it is a crime. It is a crime, my lord. So actually, an illegal act should not be allowed to be legalized by dismissing my appeal, that my application, my lord.
Just say this, we are not,
Your lordship may, if your lordship says that, then I have nothing much to say. I have only to plead with your lordship, nothing much. So your lordship may kindly show some mercy, some consideration to us, and see that the delay is condoned. Yes, my lord.
we have rejected an appeal on a delay which was less than yours. See, the threshold is very stringent parameters, what the Supreme Court say.
But
Small delay, not a negligence. It appears at least these facts bordering negligence.
But my lord, can the law be so cruel to attack, to harm the litigant not on merit, but on this particular point?
We were exercising 226 jurisdiction in this. You would have done it.
But my lord, I leave it to your lordship. I've
Difficult. Thank you. Just say this. This appeal has been filed challenging the judgment decree dated 1st of July 2022 in Form OS number 482 of 2019 with a delay of 146 days over and above 60 days, which is permissible under section 13(1)(a) of the Commercial Courts Act. On the last date of hearing, Mr. Ram Mohan sought time to file an additional affidavit explaining the delay. The same has been filed. The contents thereof reads as under. There is no document. The reasons given, the explanation sought to be given for the delay of 146 days is that the appellant was that the managing partner of the appellant organization was sick during the month of July, August 2022. Seriously sick. The same continued in the month of September 22 as well. It is also stated that his financial position was so bad that he was unable to meet the bare minimum expenses. We are not convinced by the aforesaid explanation sought to be given to explain the delay of 146 days. The Supreme Court in the case of Government of Maharashtra versus Borse Brothers, Civil Appeal number 999 of 2021, has settled the position of law in respect of condonation of a delay, more particularly in a commercial appeal. The relevant paragraph of the same is reproduced as under. In view of the settled position of law, the delay being 146 days over and above 60 days, and we are not convinced with the reasoning given by the appellant, the delay of 146 days cannot be condoned in the facts of this case. Resultantly, IA number so and so is rejected. Consequently, the appeal is also dismissed. Appeal and connected application are dismissed. Thank you.
Mr. Rajman.
Next.
28 Arjun, 29. Number 29.
May I please, Your Lordship, appear for the appeal?
Yes.
My lords, we are on the condemnation of delay, my lords.
This is huge.
It is huge, my lords.
Yes.
Your Lordship, I would request this honorable bench, while considering the application of condemnation of delay, to consider certain facts. My lords, in this case, the appellant is a resident of Kanpur, Uttar Pradesh. So when the case was instituted against him in Karnataka, he engaged his counsel in Kanpur, who further engaged the counsel in Bangalore to have the matter litigated. Now, my lords, how delicately I put in, appellant was working since the date of the order till date. The appellant was actually litigating it bona fidely in accordance to the instructions and advices of his two counsels, one in Kanpur and one in Karnataka. On 26/9/2021, he was informed,
26/9/22.
22, my lords. He got to know about the fact that an ex parte order has been passed in the commercial court. And thereafter, he again approached his counsel in Kanpur because he was acting as an intermediary between him and the counsel in Karnataka. Thereafter, they sought what they were communicating. They started establishing communications with the counsel in Karnataka, my lords. And how delicately I put in, my lords, the counsel was wrongly informed by both the counsels, my lords. It's a very critical argument to make, but that is a fact, my lords.
It's critical, so about.
No, my lords.
Action you have taken against the councils.
No, my lords, we have changed the counsel.
That's all.
No, we have changed the.
Obviously, you have to change it.
Correct, my lords.
But again, both the councils, what action you have taken?
My lords.
And the council had represented before the court when the order was passed. See the order, impugned order. You were represented.
My lords, at the commercial court also, at one point of time, the commercial court has also observed that the counsel who is representing is not interested to litigate the case.
You don't know. See page 27. Here at the bottom, representing defendant 1 and 2. You are represented. And what steps you had taken to pursue your litigation with your advocate?
My lords, we have contacted our advocate.
And mind it, let's see this. Now, when did you come to know about the order?
26/9/22.
What did you do between this period? Did you pursue your counsel?
Please, my lords, we have.
Where is your IA? Let's see the IA.
On page 133.
The judgment was
134.
dated. Judgment is dated 4/10/21.
Yes.
Please, my lords.
That's right.
Please, my lords.
And when did you receive the copy?
On 26/9/2022.
26/9/2022. No explanation between this period.
No, no, no.
What did you do after 22?
No, my lords. When this order was passed and when we received the copy, we have approached our counsel in Kanpur.
This is a question of you receiving the copy, then only you will approach. What were you doing between 20? Tell us one thing. After the filing of the suit, how many times you pursued with your counsel?
Every time, my lords.
When? On which dates? What is the written communication you have given to him? Very well, you may not have given. Orally, you may be taking it. What is the averment between 21 and 22 in your application? That how many times you had called your counsel to see what is the status and what was the response you got from your counsel?
My lords, the counsel in Kanpur was in contact with the counsel in Karnataka.
You tell us, you were based in Kanpur?
Yes, ma'am.
Did you get in touch with your Kanpur counsel?
Yes, ma'am.
When? On how many occasions? Where is the averment in the application?
My lords, we'll place the call record. We will place.
No, don't require. There should be an averment. The first thing you will say, look here, I've been pursuing. In fact, even now see in retrospect, when you're filing a condonation, there is already an order which was passed in 21. You will say, look here, even after the date also, I've been calling my counsel. He is saying the matter is still pending. He was giving some date. That's what generally happens. He was giving date. I was under the impression matter is still sub judice. I didn't know this. And you say this 20. When did you receive? Very well. When did you receive? When did you come to know about the impugned order judgment?
26/9/22. 26/9/2022.
22. Now, between 22 and when did you file the appeal?
1/3. My lords, we filed before the commercial court, order 9 Rule 13 application.
You filed it?
We filed.
When did you file it?
8/8. On 8th August 2020. 2020.
When was that? Is after how many years? More than 1 year.
8
November? Very good. Almost 1 year.
1 year.
Less than a month, less than a year. 11 months. Huge. What is the limitation?
60 days. 60 days.
You know point.
Yes.
Even for the appeal, 60 days. Okay, now what steps you had taken? Only retrieving the file or certified copy or getting in touch, he got in touch. Right, as a litigant, you may not be aware of these intricacies. We appreciate that. Obviously, you will rely upon your counsel only. But today, who is before us is the litigant.
Yes, ma'am.
Point.
And
Now, 1 minute. Then when was the 9/13 decided?
8/12/23. 8/12/23. 8/12/23, my lords.
8/12/23. When did you file appeal?
1/3/24. 1/3.
How much, after how much time?
4 months. 4 months. 4 months, my lord. 4 months, my lord.
That means what? 4 into 30, 120 days. What is the limitation? 60 days. Even against that order. See in totality. Don't say totality.
If your lordships may kindly consider it, my lords. The appellant, in this thorough period, we have not got into the major dates in each and every aspect. We have given a brief idea about it, my lords.
It's important now. We are going on the admitted facts.
Yes, ma'am.
Admitted facts.
Now, my lords, the thing is, bona fideness, we were not negligent enough, my lords, as an appellant, the appellant.
You are not saying so.
Yes, ma'am. So the appellant was working bona fidely as per the advices that he has.
That would not gel.
My lords,
That would not gel. There is a limitation. You say, I acted bona fidely. If there is a delay, I'm not responsible. Can that be an acceptable?
and your lordships not getting into the merits of the case, but I would request.
You have to cross this hurdle.
I know, ma'am.
See the stringent conditions have been laid down by the Supreme Court. Very narrow window. 60 days that they say they have interpreted to bring in that narrow window to say that only on these grounds only. Otherwise, there is no condonation.
My lords, there was an execution which was also pending in Kanpur.
Forget execution.
And he was pursuing that also, my lords.
Huh?
So he was pursuing that also in Kanpur.
That more reason when you are pursuing execution that you should go and approach the appellate court as the fast.
But my lord, unfortunately, he was never advised in that way. That is the situation. That is the.
Will that be a ground, tell us?
My lords,
Will that be a ground?
I'm requesting for a consideration of that ground. my
We
lords.
have to follow Supreme Court.
I do
We have
understand.
seen the earlier, Mr. Ramon is sitting, he's also saying what will happen if we see.
My lords, the substantial question of law in this particular case is that the ex parte order which has been passed is void ab initio.
We don't know. That ex parte, we are seeing the presence of the council. Most possibly there can be an order of ex parte,
Yes, ma'am.
maybe the ex parte, but the council was attending thereafter.
At one point of time, he has stopped attending it, my lords.
We don't know. The presence shows.
Judgment is.
And my lords, even the ex parte judgment is unenforceable, my lords. The whole proceedings were deficit in nature. The Metcon was never represented by the director. There is no board resolution on records which says so, ma'am.
No
That
statement of.
be a ground for us to, it's all on merit.
I do understand, my lords. But the only, this is at the present, and even the council in Kanpur has issued an affidavit stating so how he was interacting with the council in Karnataka. That affidavit, if your lordship may kindly permit us, we place that affidavit on.
To us.
I have it with me, the copy of.
Didn't you file it? Didn't you file it?
My lord, well, we'll file it. Today in the morning, we have received affidavits from Kanpur. We'll file it during the course of.
To us.
Right.
And mind it, even if we exclude 21 to 22, how much is the delay?
We take
Right,
that.
my lord, right now, we just have one photocopy, but we have the original also. We'll place it on. Record. This affidavit signed by the council in Kanpur.
Your council in Kanpur is based in Canada now.
Right now.
When did he go?
I know that I need to find out when did he.
Previously, was he pursuing from Canada or was he
No,
pursuing?
no,
from
he was
Kanpur?
there. He was pursuing from Kanpur. But this affidavit, he issued it from Kanpur.
Yes, difficult.
It is a humble request because there is a substantial question of law which is required to be
Maybe you may
considered.
have. But you are not, you read that judgment of the Supreme Court. And Supreme Court is very clear.
My lord,
And this is 671.
My
Let's
lord,
put it this way. Exclude 21 to 29, 22, 1 year. How much is the delay still?
361.
Sitting? And after 22, you filed it in. When did you file the appeal? Very well. That little window you are pursuing 930. Let's exclude that. Still, there is a huge delay even after 913 was decided. Beyond 60 days. That is actually has no explanation. That will actually have no explanation. I think that's crucial. No, 913 is rejected, immediately approach. So that whatever benefit I can get, you can get. At least you will be able to satisfy the court for the reasons beyond your control you could not approach. At least this period, if I am in time, please. That shows you were not diligently prosecuting. At least we don't know about the litigant, surely it was. Who was the counsel who filed 913? Were you the counsel?
yes,
Very good. So we leave it at that. Difficult.
my lords. Because there is a substantial question of law which is to be considered, I request this honorable court to kindly consider it, my lords.
We will not, we have to go by the law.
Please, my lords. But even in many cases, the Supreme Court also say that if the bona fide.
That's not in 5. Find it, we are not under section 5.
I do understand.
Okay? We'll close it. 671 more. Not in these ones. Possibly, take your chance.
My lords, the ex parte judgment is void. It cannot be executable even. My lords, if
Right.
this, because my lords, there are 3 points which is required to be considered. Firstly, the whole proceedings which were conducted in the commercial court were deficit in nature. There is no board resolution on record which says so that Medcon.
Did you file written statement?
We had
Right.
sent the written statement.
My lords, may I have a say in that written statement issue? My lords, insofar as the written statement is concerned, my lords, they filed an application after 120 days that was rejected. This was during the COVID time, and wherein the Honorable Supreme Court had suspended the period of limitation at that point in time. It was still rejected.
Till when?
My lords, this period was
Was the suit filed? When were the summons issued?
my lord, suit was filed on 27 for 2019.
19,
Yes, my lord.
before COVID.
Yes, my lords, but
Summons issued.
summons was issued, my lords.
The summons.
Yes, we have on 9/10, 9/10/19, 9/10/2019.
Count 120 days thereafter.
Thereafter, my lords.
That will expire before your COVID.
Yes, very well, my lords. But then thereafter, my lords,
You lost your chance by that time for filing written statement.
my lords, but even thereafter, my lords, they have gone on deficit court fee. There, it is staringly against section 149 of CPC. They have passed a judgment and then thereafter asked them to put deficit court fee. They have asked them to fill in the deficit after passing of the judgment. My lords, and also statement of truth is not there in this. Without statement of truth, they have proceeded with the matter. And it is staringly against Order 6, Rule 15A as
Surely
amended.
you would have looked into
Yes, my lords.
in time, on time. Right?
Yes, my lords.
If statement of truth is not there, the major
Yes.
deficiency. It's
My lords, the board resolution is also not there. That Mr. Gopal Krishna can represent Medcon.
not at your behest.
But the order per se is not enforceable.
Close it.
Okay.
Just say this. Appeal has been filed. You know, we are harsh. We are bound by the law. Narrow window, we are not. Really, yes, we know these things happens. The litigant may not be knowing it. What will he know? He has reposed faith. We are bound by law. Had it been maybe section 5, possibly yes. Possibly yes. And there are n number of judgments on this. The litigant must not suffer. They are there.
Yes, ma'am.
We say that the appellant between the suit filed against the appellant's behalf with the respondent by stating as under. This is the last paragraph. The appeal is accompanied by an application filed under application for condemnation of 671 days to get. The reasoning given in the showing that given in the application seeking condemnation of delay is the following. Suffice to state that the judgment decree dated is 4/10/21. The case of the appellant is that the appellant had come to, the judgment decree has come to the notice of the appellant only in the month of September 2022. That the past, even if an application under Order 9, Rule 13 was filed before the trial court, as the decree, as the judgment decree was ex parte against the appellant herein. The date of filing of order petition or application under Order 9, Rule 13 CPC has not been disclosed. Even otherwise, is that the application was rejected on April 2023, whereas the appeal has been filed before this court only on 1/3/2024. That will not after expiry of 60 days, the limitation period, which is otherwise applicable for filing an appeal under the commercial courts. Noting the position of law as laid down by the Supreme Court in the Impleadment case, wherein in para so and so the Supreme Court has held as we have a view that the delay of 617 days and lack of explanation also in the delay cannot be condoned. The delay beyond 60 days cannot be condoned. And consequently the application for condemnation of delay is rejected. Application is rejected, consequently the appeal is rejected, dismissed. Thank you. Next. You are deposited the amount?
Yes, my lord.
How much?
The whole 34 lakhs, my lord.
What do you say?
We would only say that we may kindly wait.
Not on the condonation of delay, otherwise on his request.
Oh, my lord, because the judgment itself is invalid.
The judgment is non-executable.
Well, we say nothing. You want to. See, we can do one thing. We will give you time. We will make him file an application after 4 weeks. That 4 weeks you will have a time that whenever you don't want to go to Supreme Court, you can go. That would be fine.
Your Lordship may kindly grant us more than 4 weeks because
Then again, I think our order is actually not.
Okay, four
Or
weeks.
nothing doing. Nothing doing.
Why not 4 weeks?
Be sure that we will balance the equities, possibly if you have that little window which will help you in Supreme Court, it may help you, but surely not now.
Please.
Okay.
Why not 4 weeks may kindly be granted? We apologize for that, my lord. 4 weeks may kindly be granted to us, my lord. We sincerely apologize.
We will do one thing. We will do one thing, say this, how much you have deposited? No, where is the?
34 lakhs.
You deposited 27,35331.84.
Yes, my lord. And then 5 lakhs, yes.
How much that amount comes to?
33 lakhs.
At this stage, then a counsel for the respondent makes a request. You appear for respondent? Have you filed your wakalat? What is your name? Huh? No, you are with him, Gogin Company. So Mr. Bhargav, Mr. Bhargav, at this stage, Mr. Bhargav appearing for the counsel for the respondent makes a request that the amount as deposited by the appellants be directed to be released. Full stop. Noting the said submission, comma, we direct release of the amount as deposited by the appellants pursuant to the impugned judgment decree. The same shall not be released. The same shall be released only after expiry of 6 weeks from today. Okay, with accrued interest if any.
Great.
Upon in the presence of the counsel for the respondent upon identification. That's the window, we can leave it to.
Great, Lord.
Thank you. Next.
Too long. 30,
35 or back. 30, 30. Okay.
bill number 30,
For the respondent. When an application, taking interim order, after 15 days, anything from this court to because if the rent.
You are for respondent. You are for respondent.
My lords, I appear for the petition. For the appellant.
Yes, ma'am.
first they filed a couple of applications.
For additional documents.
Yeah, and others with application, which adjournment of to file objections to all the items.
You have filed the application for additional documents? No. Is it one of 20? One of 24. And this is one of 24.
Yes, yes.
Is there one more?
I have one button.
This is an application filed by the respondent for bringing on record the additional documents. Counsel for the appellant seeks and is allowed how much time? Ma'am?
For the week and
Weeks time to file it. Let them file reply, we will have it after a week or 10 days. Pardon? File it within 1 week from today. We notify after 10 days. We are fixing the date. May order if any to continue.
6-3. 35. Bill number 35.
Adjourned
31,
in the morning.
10:30. 10:30.
But both of us are here,
1 minute.
31 and 32.
Were you not informed?
Both of us are here, my lord.
At the request of counsel for the appellant, stating what is the order which we have passed. See, we specifically asked, did you inform the counsel for the other side? If we get a representation, we have informed. And just, where is that order? We want, just wait here, we want the counsel who has mentioned the matter in the morning. Ma'am, just see who is the counsel who mentioned it.
Sir, for appellant, sir.
You have any other counsel with you?
Lord,
See, someone was mentioning on behalf of the appellant.
Lord, Mr. Jagdish, DC is the appellant, my lord, the counsel for the appellant.
At the request of the appellant, I have noted it also.
Now your lordships have adjourned it to, my lord.
Pardon?
The date up to which your lordships have adjourned.
What is the date?
23-4, sir.
Lord, we would be in difficulty then, my lord, because
We don't want, our more concern is the person who has mentioned.
Made
it
the
without
mention.
Informing the other side.
Lord, not only that, my lord, I am not informed, I am waiting
You
for
may be right, but this is a representation on behalf of the appellant.
We'll have to inquire with our,
Who is the counsel who is briefing you?
Lord, Mr. Jagdish, DC, my lord. I'll ask him.
We want that, please kindly ask.
Yes, my lord.
We want to know what is his response.
Yes, my lord, I'll do that.
Kindly ask, get back to us.
I'll do that.
Just wait. then we will seek in future, maybe discomfort for all the advocates.
Absolutely, my lord. They should.
All the advocates are discomfort. We want the person should be there, and we will now start recording the presence also.
True, my lord.
It may so happen sometime now I am realizing it, there are more than one respondents, counsels are different. They say, I have informed, he may have informed only respondent number one. What about the others?
True, my lord.
Very good. We don't want to take it further, please.
Please ask him.
Just get the instruction.
Yes, yes.
Yeah, surely. No, but the only thing is very well.
Lord, this is, Lord, because they may execute the decree, my lord, and we would be, my lord, dispossessed. That is the urgency in this matter. Lord, I agree, my lord, I agree. If there is a mention made.
Paid on behalf of the.
Absolutely, my lord, if there is a mistake on part of the advocate on record, my lord, then can't help it. Yes.
Bill number 35.
Your Lordship, the counsel is before another court, but I will commence arguments. Your Lordship.
Bill number 35. sir.
Yes, ma'am, tell us.
Your Lordship, it was argued in, a part of it was argued already, so I just refresh. So there's NHEI has passed an award for compensation, and then that has been challenged before the DC. And the impugned order is the order dismissing my appeal under 34(3) because it has passed period of limitation. My contention is that I have never received the award. So 34(3) is very clear as to the aspect that the period of limitation starts running from the date of receipt of.
The award.
Yes, Your Honor. The award.
No, you will give us these dates.
Yes.
When was the last hearing took place before the arbitrator? Okay, that's one. When was the award passed? When did you came to know about the passing of the award? These 3 dates we want to.
State of proceeding, I am unaware.
When was the last, when was the hearing took place last to hearing? Do we have those dates?
Physics. Yeah. When the award was passed dated, basically,
No, 11/4/2000.
When did you come to know about the award?
Your Lordship, I have not written the date on which I have come to know.
Right.
But within, yes, that I cannot improve on that aspect, Your Lordship.
That would be
No,
difficult.
Your Lordship, I'd address arguments in that regard, Your Lordship.
Did we hear
I
this
have
matter?
in part.
Yes. Tell us one thing.
Yes, Your Lordship.
The limitation would start running
Yes,
the day when you receive the award.
yes,
Okay.
yes,
Let's assume you say you have not received the award.
yes,
You did not receive it,
yes,
but it's a fact that you filed 34.
yes,
You filed,
yes, Your Lordship.
okay. How did you file 34? With an award?
Yes, yes, Your Lordship.
When did you receive that award?
Your Lordship, it is, I have filed and I have given them a notice stating that arbitration proceedings were held, and after that you have not passed an award. And then subsequently I got to know is what my application, I have sent them a representation. Arbitration proceedings were going on, Your Lordship, and after a period we have not received a notice of the proceeding. Hence we have made an inquiry. And then we've got to know that an award has been passed. Your Lordship, I understand that Limitation Act is set up so that I do not sleep on my rights. If I had come before the court after a lapse of 4 or 5 months, I understand I cannot take this contention. I have come only 30 days later because I have not slept on my rights. I have been diligent. I have inquired at the office, then got to know, and then I have made an application under 34. Your Lordship, my contention is very specific, that under Negotiable Instruments Act or a lot of acts. No, no, Your Lordship, no, yes, Your Lordship, my submission is that a lot of statute mention that limitation runs from the date of award or delivery of notice. Arbitration Act is specific that it says receipt of award because it is a proceeding as such that people may not be aware. Your Lordship, I may be permitted.
When did you receive the award?
Your Lordship, the date is not there. But within only 1 month, I have made an application.
So 3 months, beyond 30 days, and thereafter you came.
Yes, Your Lordship.
That will be not maintainable.
Your Lordship, I may be permitted to make my arguments, Your Lordship, then. Then, because
we will not say anything. You will now continue.
I apologize, Your Lordship. I'm just.
We are saying so,
Go ahead.
right. You should allow him to speak. We are only putting, let's express ourselves. We are only saying 3 months, 30 days,
Yes,
the right gets foreclosed.
yes,
Okay?
yes,
You have no, it can't be even condoned. Those are the line of.
yes, yes, yes,
What will you say on that also? Kindly say.
yes, Your Lordship. Your Lordship.
Tell us.
Your Lordship, General Clauses Act, Section 27, talks about service by post. Now, Your Lordship, it is not contested that they have not sent the post by RPAD. They also do not have any proof as to my receipt, whether it has been served, and not, and I have refused it, or address is not correct. There's no acknowledgement as to that aspect. They will not be in a position to furnish proof in that regard. So it is ordinary post. Under 27 of General Clauses Act, its meaning of service by post is where any central act or regulation made after the commencement of this act authorizes or recognizes any document to be served by post, where the expression serve or either of the expressions give or send or any other expression is used, then unless a different intention appears, the service shall be deemed to be effected by properly addressing, prepaying, and posting by registered post a letter containing the document, and unless the contrary is proved to have been effected at the time at which the letter would be delivered in the ordinary course of post. Therefore, always in wherever there's a matter of service, this is an authority, there's a higher standard of diligence that they are.
Is this relevant?
Your Lordship, it is relevant because 34(3) specifically says that receipt starts from my course.
You have filed 34.
Yes, Your Lordship, I have to.
Not the award.
Yes, Your Lordship, it is not. Your Lordship, I'll refer to judgments then in the.
Question is, when did you receive that warrant?
Your Lordship, the date as to when I have received, I have not
Important.
made.
For the reason you filed a 34 after receiving the award.
But I have not received, Your Lordship, it's important that I read 31, which says how it is to be delivered. Delivery is only deemed if they serve it on me. If I go to the office and take a copy, then it is.
No, the court wants to know, how did you receive the award?
Your Lordship, I went to the office
What
and then.
was that date?
Your Lordship,
That's what. See, these dates become relevant. You will say specifically, I did not receive. I went to their office on that day. I gave this representation. I have asked in the copy of the award, which they gave me on that day. That means my date of knowledge of the award or receipt of the award is this, and I am coming within limitation. That will mean say in 34.
Your Lordship, my contention is not that I come within limitation because I'm giving sufficient, Your Lordship, due to lack of experience,
We are not, we are doing
My-
our best. Best.
my phrasing of the submission may not be the finest, but if the court were today to hold that were to dismiss my petition because my lack of explanation as to my receipt, then the court would inadvertently hold that the proof of their service would be contingent on my explanation of receipt. That, in my humble submission, cannot be correct.
If we were to
Because-
ask you, you received the award on the date when the award was passed. How would you controvert it?
Your Lordship, there are judgments which say that even if they have personally served it on my office, but I have not received. Or in another case, if my advocate has received and I have not received, even in that case, section 34(3) limitation does not start running because the specific terms of the section 34(3) is that I have to receive. So even in a case if my office or my advocate does not receive, but I receive, that means the court is very liberal in my receipt.
Yes.
No,
That the appellant had not received, the advocate had received.
no. It is my case that the burden of proof is not on me.
Okay.
The burden of proof is on him that he has served it on me because it is not delivery that is in question. It is service.
It's not the arbitrator. You have to get the award from the arbitrator.
I'm not, my allegation is not on him. It's on limitation.
Right, on the arbitrator.
Yes.
You have to receive.
Yes.
But you have received it. That's the reason you have filed 34.
It does not count as receipt is my contention. I have to, Your Lordship, no, Your Lordship, because section 31(5)
Like that, let's not go into it.
clearly states how it is to be delivered.
Then please.
Yes, Your Lordship.
When you say you have not received it when you have filed a 34.
No, I have received the order copy, but it does not amount to receipt in terms of Arbitration Act.
But you still filed a 34. Still filed a 34.
Yes, Your Lordship.
Because you have received it.
I have received it, but it does not count as receipt because delivery under Arbitration Act is not in that.
34 court.
Paragraph number 17. Paragraph number 17.
The challenge in this appeal
Page 9.
is.
Your Lordship, I may permitted to give judgments, Your Lordship, in this.
Oh, it covers the issue what you are arguing.
Yes, Your Lordship.
Give us. It is the best judgment. You will give the best judgment, saying that even though you have received, even though you have the data, even though you have the knowledge about the award, you got it, but it must be construed you have not received it. That's what you are arguing.
Yes.
No?
No,
Give us.
I have received the award as in it is in my hand, Your Lordship. My statement is that section 35 contemplates a manner of receipt, which is very specific. In that terms of the procedure, I have not received. I am, of course, not in a position to say that I do not have the award. Of course, I have the award. I am saying that receipt.
You do not have filed 34.
Lordship,
You
there
would
is.
state in the manner contemplated under 31, for you to receive the award, then go to the 34 court saying that in the manner contemplated under law, I have received the award on this day, I am coming in time.
Then in all due respect, I would still be waiting for the order because they are contending that they have served the order, Your Lordship.
Very fine.
You give the judgment, we'll pass the order. We'll deal with those judgments also. Just say this challenge to the order is in 19th August 2003. By the learned court has dismissed the IA number, was it, which IA number for condonation?
1. It is 1.
IA number 1.
1.
Of 2000. IA number 1 in the appeal case number 111 of 2016.
Your Lordship, I am sorry for interruption. I'll just give the judgments, Your Lordship, and then. Yes, okay.
We are
Yes.
clear.
Yes, yes.
Whether the learned court has dismissed the IA number 2, which is an application seeking condonation of delay in filing the petition under section 34 of the Arbitration and Conciliation. The facts to be noted for the purpose of this order is that the parties herein pardon? 1 minute. This is page number 35. Section 54 of the Application Section 3(b)(6) of the National Highway Certificate by limitation. That's to be noted for the purpose of this report. That the was the absolute owner of a renewable property during survey number 68 of 68 only case measuring 0.22.00 acres of land at Terminal Village, virtue of a COD dated 1/11/1962. The out of the I'll just say that it was her case that after purchasing the said property, he made improvements by spending huge amount of money. About 22 cents of land has been acquired for the purpose of widening the national highway. The land was acquired for widening the Railway National Highway, fixing 1,50,000% as the compensation payable on all lands. Personally applied by Terminal Village. The problem being agreed by the compensation granted by the Special Land Acquisition Officer filed a claim petition before the arbitrator under section 3G5 of the National Highways Act 1996. The arbitrator, considering the governments made in the claim petition, passed the award dated 11/4/2017, enhancing the compensation amount from 175 to 170. Being agreed by the included award as well as an arbitrator. The plaintiff approached this court, the court below under section 34 of the Act of 1996. In case of the plaintiff not agreeing, that the included award passed by the arbitrator was opposed to law and is unsustainable. on the other hand, the NHA has justified the award passed by the learned arbitrator. The said petition under section 34 was accompanied by an application seeking condemnation of delay of 65 days. 65 days, no?
Yes, yes.
First, the case of the plaintiff in support of the application for the delay was that
It's in my affidavit. It's in my affidavit, Your Lordship.
in the affidavit,
Yes.
That the award dated 11/4/2017 was not communicated to her. She came to know about the impugned award passed by the learned arbitrator in the last week of August 2017. Immediately thereafter, she obtained the certified copy of the same and filed the suit. What was the date of filing of the suit?
21/9/2017.
21/9/2000.
17.
21/9/2017.
Yes, I should have filed on 10/8/2017.
It is a conceded case that is plaintiff that the petition in terms of after 3 months or after 3 months, 30 days?
No. After 3 months, 30 days.
The limitation, the prescribed limitation otherwise would have expired in the month of August 2017. What is the date you said? 30th of August?
11th August, I should have filed.
11th August 2017. It is considered that the petition under 34 was filed in the month of September 2017 with a delay of 65 days. The learned trial court had on the issue of limitation as in paragraph 16, 17, 18 has held as while rejecting the plea of condonation of 65 days as stated as under mission of the learned counsel for the appellant is that the learned arbitrator, after hearing the parties had not fixed a date for the pronouncement of the award. According to her, neither the arbitrators had sent a copy of the award dated 11/4/2017 to the appellant hearing. Schedule 17. While filing the petition, there is no specific averment made as to when exactly the appellant had received the copy of the award dated 11/4/2017. It cannot be, it is a fact that the appellant did file a petition under section 34 of the Act of 1996, which means that the petitioner is in receipt of copy of the award. Copy of the award. Though the date of receipt of the copy of the award has not been mentioned, but the fact that the petitioner, the plaintiff had filed an application seeking condonation of delay of 65 days in filing the award, which means the delay that has occurred is over and about 3 months and 30 days. So the law in this regard, as noted by the learned trial court. Which are the judgments you are relying upon, ma'am?
There are 3 judgments, Your Lordship. I'll rely only on 2. I will read out 2, Your Lordship. One is the Honorable Supreme Court's judgment in Teco Trichy, which is 2005 4 SCC 329 239. Yes, Your Lordship.
Which paragraph?
Para 8. Your Lordship, in this is the case I was referring, in which the office of the railways had received it, but it was not given to the general manager who was the party. And even though his very office had received it, date of receipt was not taken on that day, because 31(5) clearly says that it is signed copy shall be delivered to him. Therefore,
which office according to you has received it? In your case.
Your Lordship, it's not my case. It's my case that we have not received it in the terms of the word receipt. Your Lordship, the legal meaning of receipt is different from the English common parlance.
Yes.
So in the English meaning of the word, I have received it. It is in my possession. But it is not receipt because it is not delivery in terms of Arbitration Act. Because it's... Your Lordship, then the question before the court is, in a case where the authority never delivers.
You have not received it? In the manner known to law, you will sit quiet. But having not done that, and having filed a 34, you will take the risk, you have taken the risk.
Then I have no remedy, Your Lordship.
You will sit quiet. You will say, when actually you receive the award, in accordance with the, the procedure of the law, you will say, I have received this day. And within that time, I have approached.
Lordship, in 2017, the award is passed. As on today also, the contention of the arbitrator is that they have not delivered.
Why?
Your Lordship, then I'm without compensation, or my matter is neither before the court. I'm remediless.
Knowledge is there. What did you say?
Your Lordship, I'll read the judgment.
Pardon?
I'll continue reading the judgment.
Tell us, yes. Sorry, yes. Which paragraph you said? Para
8.
8.
Okay.
Your Lordship, the entire para is...
Whichever the relevant lines, tell us.
The first part, they decipher receipt. The first part of the para. So they say that it is only after the stage under section 31 has passed that the stage of termination of arbitral proceedings within the meaning of 32 of the Act arises. The delivery of the arbitral award to the party to be effective has to be in courts received by the party. This delivery means on my receipt. This delivery by the arbitral tribunal and receipt by the party of the award sets in motion several periods of limitation, such as application for correction and interpretation of an award within 30 days under section 33. 1 and an application for making an additional award under 34. I'll come to the last part of it. Last 4th line. As this delivery of the copy of the award has the effect of conferring certain rights on the party, as also bringing to an end the right to exercise those rights on expiry of the prescribed period of limitation, which would be calculated from that date, the delivery of the copy of the award by the tribunal and the receipt thereof. I stress on this, that delivery is different, receipt is different. Delivery and receipt thereof by each party constitutes an important stage in the arbitral proceedings. So in the last page, Your Lordship, last page, para 10, last 6 lines. Therefore, in our opinion, service of the arbitral award on the general manager by way of receipt in his inwards office, in fact, they've received, cannot be taken to be sufficient notice so as to activate the department to take appropriate steps in respect of and in regard to the award passed by the arbitrators to continue the starting point of limitation for purpose of section 34(3). So then they take service of notice when he himself personally has received the award. Your Lordship, there are a lot of judgments in this regard, which is very liberal in aspect of my burden. The burden is not on me because the proceedings are of such nature that receipt has to be specifically proved. An authority with such a high standard of proof cannot post an ordinary post. They should have at least made a registered post to have my receipt when, Your Lordship, there's a specific use of the word receipt. They should have used RPAD. This is only an envelope which says that they have sent. There's no contents, there's no mode of proof. Your Lordship, there's also Bombay High Court judgment. There's another Supreme Court judgment, but I would not trouble your Lordships with that. There's a Bombay High Court judgment that I would rely on, which is 2018 SEC Online Bombay 538. Your Lordship, in this para 13 is with regard to facts. I believe it would be similar to my case. In the third line, the postal track record also does not show the envelopes containing copy of award was dispatched by the arbitrator. Same in my case also. They talk about how the endorsement is given, RPAD is not used, there's only a cover. Then in para 14, they say, we find certain infirmities in respect of service of award claimed to have been made on the appellants. The acknowledgement, receipt, or forwarding of the postal envelopes is not found in the arbitrator's proceedings. It's not found here also. The detailed track events are on record which show that some of the appellants received the envelopes. It does not establish as to who had forwarded these envelopes on the address of the appellants. There is nothing on record to show that the arbitrator had forwarded the copy of the award which is said to have received by the appellants.
Yes.
Your Lordship, on the last para, the operative portion, it says in para 20 and 21 that considering the object of provisions of section 34 of the Arbitration Act and in view of absence of conclusive material on record in respect of delivery of service of arbitral award on the appellants, a case is made out by the appellants that they were prevented by sufficient cause from making an application. Your Lordship, there's only two contentions. One is that in an application, in a section where the statute reads that if the court is of sufficient reason to condone the delay, I understand that my application, my explanation has to be in detail because it is to the satisfaction of the court. This question here is on a technicality as to receipt of award or no. If after the receipt, I have not made sufficient cause for that 30 days, then I understand that it has to be gone into the nitty-gritties to prove that sufficient cause is there. I have a sufficient cause. But this is a case of receipt or not receipt. Courts in all the judgments have taken a very liberal view as to my burden. The burden is on them. Second, Your Lordship, and my last contention is in the Arbitration Act itself. There is a section 3. Section 3 says receipt of written communications. Unless otherwise agreed by the parties, any written communication is deemed to have been received if it is delivered to the addressee personally or at his place of business, habitual residence, or mailing address. The next page is not, next clause is not relevant to me because it is if there's no address given. Second clause, the communication is deemed to have been received on the day it is so delivered to me. So when there's no registered post, ordinary course of proceedings, this Arbitration Act is not an act in which they can rely on an ordinary post because it uses the word receipt. And even in the Bombay judgment, they rely on section 27 of General Clause Act, which says what service of notice is.
Thank you. You did a great job. Okay, you have done your job, but we are still not. We'll complete the order after going. You have anything to say?
Nothing, will see, yes.
He has done a good job. Thank you.
Grateful.
We'll just complete the order.
Yes, Your Lordship.
But we will still hold the same view.
Yes, yes, yes.
Court was right. Thank you.
Yes, grateful. I'm sorry if I've interrupted the court.
No. We are sorry. I think we have interrupted you. Thank you.
Great.
Next.
Thirty-seven. Dilemma 37.
Yes.
Stating that earlier there was an order to connect other three appeals in this case.
He'll file an application. Not like this. It's a memo.
My lords, earlier there is an order, my lords. I'll
Show us the order. That's
order
enough.
sheet also.
Show us the order. Part of this appeal.
Yes, my lords.
What is the date of the order?
Let's order dated 23/12/2021.
In which appeal?
Mallards in 138 Mallards, but in that order Mallards on 23/12/2021, list along with commercial appeal number 137 of 2021 Mallards. This appeal has to be listed with that appeal.
When is the date there?
Mallards,
When is the date there?
they have not given any date in that case. And also on 22/5 Mallards, other two appeals are ordered to be listed with along with these two appeals. 22/5, registry is directed to list these appeals, that is 137 and 138, along with commercial appeal number 75 of 22 and commercial appeal number.
Now, who are the councils there? Who are the councils?
Let's it's, I have informed them, Mallards. I'll be mentioning this and I'll file the memo to that effect.
But there is no order in this appeal to list this appeal along with those three appeals.
That's but
other way.
But if we see in the online order sheet, Mallards, this order dated 22/5 is visible in this appeal also, Mallards.
This would have been done there. According to that. Those two appeals, 137.
Just say this, we learn a council. The appellant is saying,
Yes, Mallards.
Advocates
who are the respondents? Respondents is also same.
Yes, Mallards.
The councils must be same also.
Yes.
And this 75 and 76 is also by you?
No, Mallards, by them. By the other side, they have filed the appeals in that.
Again, the same impugned order?
Yes, Mallards.
Same.
Same. Because in the,
The
I just,
council for the appellant has drawn our attention to certain orders passed in COMAP 138 of 2021, which is also an appeal filed by the appellant against the respondent herein, to state that in the order dated 22/5/23, that appeal, in dated 23/12/21, in that appeal, to list the COMAP 138 of 21, along with this appeal being COMAP number 137 of 21. So he also states that in the order dated, in the same appeal, vide order dated 22/5/23, this court had also directed the registry to list the appeals. These appeals means which appeals?
137 and 138, Mallards. Because that, these
137
appeals
of 21, 137 of 21 and 138 of 21, along with COM map 75 of 22 and 76 of 22, which we have been informed are the appeals filed by the respondent herein BEML. That's right. Appropriate shall be that the council shall file a memo by serving the same on the council appearing for the BEML. And okay. Just give it to, just do that so that they are also privy to that, so that we can club everything. That's right. Thank you. We will just adjourn it so that we can have all the four. By the time you file memo, everything four will come.
Please. Mallards, if your lordship may mention that if the memo is filed, all the four appeals may be listed together, maybe listed state. If the memo filed.
No, I was just only thinking, when you mentioned that memo before us, in the presence of the council, the other council, we want him to be there. Will it be possible?
Please, Mallards, I'll contact him.
And just contract anything so that they should be privy to that, so that all four are coming together. That's the intent. Okay.
Fifteen four. 38. Serial number 38. My lord, I appear for the appellant. The appellant is the CPWD. Central.
We notify, we will have it some other.
My lord,
For what? Objections for?
I,
Well, let him file.
this,
We're gonna counsel for the respondent seeks and is allowed 6 weeks to file with objections, reply to the IA 1 of 25, which is application for additional documents filed by the appellant's hearing, filed by the appellant hearing.
24. Serial number 39. Shobhit Shetty, 39.
Appellant in this matter, section 37.
We'll have it some other day, Mr. Just re-notify. Stand here, we, shall next.
3.
See, it's not possible, March. Just wait. If you want, we can give you June.
3, 3, 4, 40.
My lords, I appear for the appellant in this case, my lords. I appear for the appellants in this case.
Which number?
Serial number 40, sir.
40.
I appear for the appellants, my lords. This matter was heard and then reserved for orders. Once, before a coordinate bench, not by my lordships, by another coordinate bench. Thereafter, when the matter came last time, it appears this court had asked us to file a written submissions. There is already a draft lease deed.
Yes. Yes, Mr. Samuel.
Lords, I'm not able to hear the court.
Now you go ahead, What are you saying?
Well, what I was saying is, my lords, we had argued this matter at length. Matter was reserved for orders. Thereafter, it was released from Mathar. Then it came before my lordships on a few weeks back. This court had directed us to file our written submissions. In the meantime, I've also given a representation to the corporation with regard to the lease deed which the legal department had already finalized to give effect to it. My representation is there before the corporation. And I'm given to understand it is once again been sent to the legal department. If something fruitful comes out of it, then we both can place it before this court and say that in terms of that, it could be disposed of.
Yes.
So if some time is given, my lords, I will be in a position to report to the court. I can't hear my learned friend, what he's saying.
This tender now has been stalled from 2006 up till now. What had happened is the property not situated in Indigo. This is where 22,000 square foot of area is being occupied by the resident.
Yes. Now what has to be done?
Lords, if my lords would see page number 224 of the paper book, I've also enclosed a draft of the legal, the lease deed which has been.
We'll hear it. We'll hear it. We'll just decide. Just have it.
Lords, after the 5th, my lords, because I am not available, I have a personal. Lord, if my learned friend could just speak into the mic, I'll be grateful. I'm not able to hear him.
You repeat it. You repeat your submission. Obviously, he has not heard you.
Only thing is,
I've not heard him. I've not heard him.
I only say that, my lord, 6 crores is the amount of due as on the date when they filed their appeal before your lordships. My lord, when the interim order was being considered by this court, my lord, 60 lakh was directed to be deposited. They have accordingly deposited this amount. They are liable to pay this amount to me. From 2006, my lord, they have been squatting over the property without any
lease deed in their favor. Earlier, there was a lease deed. That lease deed comes to an end in the year 2005. From 2006, my lord, I pass a resolution. I take a decision that this property has to be put into auction. Now, my lord, they run to the commercial court. They obtain an order of status quo as against me. Since 2006, my lord, nothing has happened. The amount of
We will set out for hearing. Just put it in first or second week April.
Please.
List this appeal for hearing on
8-4.
Please.
next.
8-4, madam. 8-4.
April 8th, sir.
Great.
42. Serial number 42.
Appearing for respondent, my lord. Kindly please pass for senior on.
42. Kindly fix for a date for admission and hearing.
Just say that at the request of counsel for this is a trademark matter, no?
Please, please.
Just that list for hearing on
36. 44. Serial number 44. Shri Balakrishna Shastri.
For the appellant. Permitted to submit my presentation. May take only 1 minute for your lordship. Suit for recovery of money, plaintiff's appeal. During the course of time, the suit is filed against the debtor's wife, son, and daughter. Debtor first against wife, son, and daughter. Trial court after trial holds that there is a debt, liability is proved, but on the account of section 6 subclause 4 of Hindu Succession Act, buyer's obligation, they would not be liable. That is why son and daughter. Also, not sought personal liability of them at all. We are going against the father's property. We have sought attachment before judgment was allowed. Exhibit P 17, 18, and 19 are properties of the father which have been shown. And it's only on the account that wrong section has been quoted. That is section 50 of the CPC. That is not where the decree is executed. I have legal representative.
what do you want?
One I'm seeking for attachment before judgment. I have filed an IA 120.
Who is representing the respondent?
No one, my lord. Notice has not yet been ordered.
We'll just issue notice.
Property was attached even for the trial court. Stated in there.
That is, there are not, we have to see.
Issue notice, serve them, serve the other side. Returnable on.
24-3. Serial number 45.
Notice was not issued, no?
No, sir, notified.
Forty-five.
45.
Yes.
Shri Raghavendra.
Yes.
But respond number 1. He files a suit against respond number 2. Seeking recovery of certain amounts. And that suit is decreed. The appellants herein, my lord, they are not parties to the suit. While executing the decree, without filing the necessary application as contemplated under the Act, the decree holder, respond number 1, he only files a memo, attach the movables. He gives the list of movables. And those moves, they do not belong to the judgment debtor at all. It belongs to the partnership firm. So attachment order was made. Then application came to be filed under Art 21-58, claiming title to the property. That application is decided and they have been dismissed. Against which this appeal is filed. But if your lordship sees the very pleading in the plain, the transaction is different. Your lordship may kindly see the loan transaction between them.
Yes, so for R2. We will hear it. I think we better put it for hearing. Just later re-notify for hearing on. Paper books, अच्छा this is com appeal, na?
23-4.
interim order, can you make?
Interim-
My problem is that the order is executed.
Order is?
Order is executed. I collected some material, the electronic material. If kept as it is, the later on it will not use it.
Later on?
Later on, it cannot be used for anything. Something has to be done for that. Either
Who
it
has-
has to be handed over to Amina.
It is,
Court officer, it has to take. After that, the appellant filed the appeal and application, suppressing all those.
Where was, no, to whom it was the,
The.
court's custody. No.
I don't want to take that risk.
no, what is the product?
A product is the screen and also some electronic item, just like projector.
Oh,
What is the items why I mentioned memo?
who should get that? He should get that.
No, he's
Huh.
not the one. They are on their own admission only the order came to be passed.
So,
So I had to hand over to the court to take the next steps to put it in the public art.
That is stayed.
No, not stayed, not stayed.
That is stayed. Your lordship may kindly see the interim order.
That is not stayed.
no, what did the trial court held on this,
Trial court issue the warrant. Warrant is executed.
on this material?
Yes, madam.
What does the trial court say?
The trial court is, see, they say that the Amina handed over to me according to the trial court direction. I am keeping that.
No, for what purpose it was handed over?
No, just to collect and keeping, that's all.
Just show us, man.
Yes.
See, it can't be unless and until maybe. No, where is the decree?
In my statement of the objection I made it by stand clear, madam. Para number,
See, it can't be in vacuum, na?
yes, madam. That's why, if the lordship permitted, I'll hand over to the civil court.
Why?
Whatever the material hand over to me by the Amina court officer.
We want to know, why was it handed over to you?
Yes, madam.
Which paragraph?
Para, madam, I stated para, para. Two, madam.
Now, even if it is put in auction,
Yes, madam.
who will get the money?
No, I have to deposit in till finality of this the appeal, I have to deposit in the court.
Let's assume.
Yes, madam.
What was the dispute about the material between both of you?
No, I don't have any dispute with the appellant who are before your lordship.
No, whose material, whose
That's
material?
Shekhar, that is the second respondent.
Second respondent's material.
Yes. Against him, the decree was passed.
It is
No,
not second.
Is he a party?
When execution is filed, these appellants are come to picture filing application or order 21-58. That application came to be rejected. Against that application, now the appeal is filed. A clear finding in the order, the impugned order, he said that the item on which they are claiming the title, that is not the item.
Where does the court deal with this material?
Will it kindly peruse para number 12, my lord, of the impugned order? On perusal of the above evidence, after taking the evidence of OW 3, OW 1 point of clear, according to him, the JDR herein has resigned from the so and so, and his account has already been settled. Therefore, he has no right and interest over the whatsoever nature. It is also contended that managing part of the LLP are having the absolute right and interest over its assets. But the first objector not produced a single piece of document showing the list of property owned by the LLP. It is further case of the objector one that the attachment warrant issued by the court in respect of the properties referred under it are absolutely belong to the LLP and JDR no kind of right over them. If such would be the fact, the objector number one might have have some document to show that they are having right over the property. That is the second appellant. This first appellant is concerned. Kindly peruse para number 13.
Yes.
After explaining all the background matter, in page number 38, my lord, after 10 lines, the alleged retirement of the designated partner so on. So it creates a doubtful circumstances. The document relayed by the objector in support of his claim under IA number 1 are not only the contradictory to each other, appears to be said destructive. Hence, they cannot come to aid of the first objector in establishing their claim. Considering this fact, it appears that JDR is supposed to be still the designated partners of the LLP. The very admission of the JDR in the course of his cross-examination, examined in DW1 categorically stated that he has invested huge amount of construction of the cinema. Admittedly, DHR has paid the amount the JDR towards the Ninter canteen proposed to be run in the cinema. Then, my lord, as far as the first appellant that para number 15, the EZMA, first appellant admission, the evidence, my lord, that extracted in page number 41, my lord.
Now the presence of respondent number 2 is required.
It is required. It is required.
Although he has been served, Mr. Vijay Kumar is appearing for him. See, we can work out the material.
Yes.
He will have a claim on that material.
This one I have. According to the court, he is the owner of that material. Second respondent is the owner of the material.
My lords,
The lordship directed me to deposit in the court or deposit in the court.
We don't have space there. Where will we keep?
Otherwise, your lordship will
No.
go with the auction.
That's what, let's
Yes,
see,
sir.
for that we require respondent number 2.
Yes, yes. Sir.
Just say that there is none for respondent number 2. Re-notify on. When the counsel for the appellant shall inform the counsel for the respondent number 2. I will give it in April.
23/4.
I don't want to run with that risk.
Matter of another 2 months, let's see.
Your lordship.
Next,
Matter.
interim order may kindly be.
interim order if any to continue. If we come. Next.
7.
Give the date, man, re-notify. We'll have it some other day, Mr. Latif.
They are trying to alienate.
Only then we'll issue notice, let them come. Issue notice. So your suit has been dismissed.
And this is folder. And this is only on the ground floor. Attesting witness was not examined. Now this is alienate is my purpose.
Serve them. Was there any interim relief before the court below?
No.
You can't be better placed when your suit has been dismissed. Right? Issue notice.
3/4. 48.
For the appellant notes. But
Any urgency?
but there is a decree of possession, my lords. A suit for, my lord, declaration of title and consequential possession and consequential relief of injunction. Now, my lord, the court has decreed the suit. Therefore, my lord, there is a direction directing the defendant to vacate the premises, not within 3 months. My lords, 3 months is expired now, my lords.
Then you have filed execution? Just give the file. You have not? How much is the liability, monetary?
Lord, they have to pay, my lord, 50,000 on the date of vacating the premises. Lords, that is the decree, my lords. Judgment, your lords may kindly see page number 41 of the judgment, my lords.
Or actual expenditure?
Yes, my lords. That is the plaintiff has to pay to the defendant. That is the, my lord, of course, my lords, I am on the title, my lord, with respect to the plaintiff, my lord, I am the purchaser of the property, my lord, from the successors of the original owner.
You were to vacate it.
That is the problem, not, I'm facing.
Sale deed is after year 1991, my lord. Subsequently, there is a sale deed of 2004. In 2004 sale deed, I have purchased the property in question, my lord. And the very same property in 2015, since the property was a vacant land, this appellant has created the forged sale deed through the vendor of my lord. That is a second sale deed created in respect of the very same property. It is hit by section 48 of Treaty Act, my lord.
They have not filed any execution.
Lord,
We'll issue notice. Just say
But-
issue notice.
Lord, if that is the case, my lord, so let them not undertake that they will not
You appear
precipitate.
for all the
Otherwise, my lord,
respondents?
Point number 1 and 2, my lord.
for the plaintiffs
Who is contesting?
contesting.
1 and 2, she accept notice. What about 3 to 5?
3 to 5, my lord, were placed ex parte before the trial court. They were subsequently implemented by the plaintiff, my lords, who are the vendors of the defined number 1, my lords.
No, you want them here or not?
My lord, I will take notice to them, my lords.
Let notice be issued to respondent 3 to 5. Returnable on.
Order of status quo before the trial court, my lord.
They-
Based on this alleged sale deed, we should not further create a sale deed, my lord.
Oh,
Status quo was maintained before the trial court.
that's right. So you will maintain now also.
Yes, ma'am. Both the parties.
Please.
It is agreed by the counsel for the appellant.
Sole appellant.
And the learner counsel for the respondent number 1 and 2. That's status quo as existing today with respect to the property, scheduled property. There is only one property, no?
One property, my lords.
Shall be maintained till the next date of it. Okay?
Yes.
Give a date.
9/6.
Appellant.
49.
49.
I appear for the defendants, not for appellants before my lord. This was a suit filed by the son, my lord. The defendant's appeal, my lord. The suit was filed by the,
They will just give the dates.
my lords, the only issue is this, my lord. On the basis of a,
I am appearing for the creator. One more case, we filed it, this RFA, my lord. Kindly posted that, this matter along with that matter, my lord.
When is that RFA listed?
It's, we filed that suit, my lord. In the suit, just partly allowed regarding that.
Is that RFA coming?
It's, all the compliance is over, my lord, but yet to be listed. that
Yet
is
to be
fresh
listed.
matter, my lord.
my lords, may I mention, my lords, urgency, my lords. The respondent, the defendant number 1 here is a 75-year-old lady. The plaintiff is the son. He resides in the US, but his wife keeps coming and she is here in, that is the daughter-in-law, comes and lives in Bangalore. She has been threatening the possession on the basis of this impugned order, where joint possession has been given now. From 2000, my lords, I have purchased it along with my husband, that is the father of the plaintiff, and he passed away in 2015. After 17 years, the suit is filed. And today, on the basis of, my lords, on the basis that he was the real owner, though the nominal ownership was with the parents. This he claims that for 17 years he had no knowledge. And in 2017, he wakes up and says, now I get to know that though I had told my father to purchase these properties in my name, he has purchased it in his and mother's name. So I am the real owner. I can show transactions of payments being made in 2000, and therefore I am entitled to this property. The trial
Has been given.
now joint ownership and joint possession has been given. Now this fact, my lords, on the basis of joint possession in a house in which she has been staying,
If the son is staying,
My lords, she transits between USA and here, my lords. Spent substantial time here as well is what I've been informed by the clients, my lords. My lords, may make the.
For the son?
Yes.
Yes,
Milord. Son is US, my lord, that wife and children are staying here only. The child is staying in school, my lord.
You want to go back to the house?
No, my lord, not even.
Let them give an undertaking, my
They are
lords.
staying in a tenant, that's a rented house, my lord.
But you may have challenged the appeal,
Yes, my lord.
but a joint ownership has been given to the mother and the son.
Yes, my lord.
That's right.
Yes, my
You
lord.
don't want to go there.
No, my lord, they don't want to allow us to enter the.
You suppose they are keen, you will go there.
Yes, my lord, we will do that.
My lords, there is actually a threat. What has happened is,
But we are staying in the rented house.
there is no love lost anymore, my lords, between the mother and the son. So let there be status quo is let it be clubbed, my lords.
It's,
Where are they staying? Are they staying in their own house or not?
no, rented house, my lord.
My lords, the issue is,
The rent.
This, she's paying, it's more than 30,000, my lord, because it's a.
my lords, the issue is this, my lords. The husband is,
There's one thing. There is no one. This is for you.
please,
Joint ownership today given.
please, my lords,
The daughter-in-law is staying outside.
please,
Otherwise, she is entitled to portion of this.
please.
How would you compensate her?
My lords, the issue, may I place this, my lords? I would only, my lords, their claim is that they're entitled to absolute ownership of that. So that is causing the threat to possession, my lords.
Not, that's the maximum they can get. But they have got at least half of it.
My lords, after 17 years, your lordship may kindly appreciate, kindly the state of the mother, please. So till then, let there be status.
The son said, look here, I have contributed to the purchase of
Please,
this house.
please.
The case?
That is the case, my lord. My lord, after 17 years. After 17 years, my lords, there is only one important issue which I should mention, my lords. He says that I had given a GPA to my father in order to execute the sale deed in my favor. For GPA for purchase. My lord, that foundation document, GPA itself is not marked in the entire case, my lords. It's not even an exhibit. There is a finding to that effect. Despite that, on the basis of certain monies that have come from him.
Let's assume GPA was not there.
Please.
There was a monetary contribution.
My lords, there is a clear explanation on which the finding also is in my favor, which says I had funded my son's education in the US, for which he was giving back some of the money around the same time. And that has also been proven. That proof is that evidence is in my favor. Please, my lord, let that be status quo. Or let them undertake not to file any execution petition. Lords. That would suffice. Still, it is concerned.
Scheduled property.
We'll give a date, get your appeal also listed on that day.
Yes,
Please.
my lord.
Mind it, until such time, you are not proceeding against them in the execution.
Please,
No, regarding that property, we haven't do that.
please, great.
Just say this, we notify this appeal. You appear for whom, ma'am?
It's a first respondent. my lord.
Respondent.
First respondent. What about you? E only.
Yes, ma'am.
Just say that so-and-so appears for the first respondent, states that the first respondent has also filed their appeal against the same impugn judgment decree dated so-and-so.
So RFI number is 2775 of 2024.
RFA number 277,
5 of.
5 of 2024.
Yes, ma'am.
So list this appeal on that day, you get that appeal listed on that day.
Yes, ma'am.
Shall we record it? You will not, till the next date when we are hearing both the appeals, you will not take any action?
Yes, they should not allow us to enter the premises. my
Maybe
lord.
it's a matter of 1 or 2 weeks or 3 weeks. We are giving in first week of March.
Yes, ma'am.
Till such time, don't take any precipitative steps.
Yes, ma'am.
You will not file it?
No, my lord.
Sure, shall we record it?
That property wise, we haven't filed it anything. That amount is what that second appellant, she filed that she received money from us, my lord. That amount we filed that EP, my lord. 26 lakhs she received from us. That amount we filed an EP, my lord. That separate order has been passed in the judgment, my lord.
Second appellant is who?
It's a sister of us.
Sister of the son.
Yes,
the
my lord.
daughter of the.
Yes, my lord.
Please.
That amount only just we filed that.
No, we want, shall we record your statement? You would not
Yes,
take.
definitely,
Possession.
my lord.
We are only saying that the learned
Yes.
counsel for the respondent number 1 states till the next date of hearing,
Yes, ma'am.
the respondent number one shall not initiate any execution proceedings.
Yes.
Okay,
Yes, my lord.
statement is taken on record. This one.
Grateful.
Only that recovery of money, we executed we filed an execution petition.
You filed,
Yes, regarding the recovery of money, my lord.
how much is the money?
It's 26 lakhs with
There
interest.
is that,
My lords, the entire 26 lakhs has already been paid. my
Again,
lords.
the second appellant.
again, the second appellant.
Yes, my lord.
The second appellant is with you, na?
Please, my lord, second appellant also,
Deposit the money here.
my lords, that entire amount has been paid as per exhibit D6. That has not been considered by the learned trial.
We will say, there is a money decree against you.
Please, my lord. My lords, in a money decree, my lords, this is completely hit by order 3 rule 4, my lords.
You will see.
There cannot be a joinder of suits. It's a composite suit where the joinder cannot be done, my lords. It's a different property altogether. It's not Schedule A or Schedule B. Different cause of action.
They rightly or wrongly, there is a decree against you.
Please, my lord.
So you will deposit in the court.
My lords, about 25% payment, my lord.
Amount 25. How much is the amount?
It's
Yes,
amount
you
is
can
26. It's 26 lakhs, my lord, 25 lakhs, 98,934
The
plus
appellant-
interest of 6%.
The appellant number two shall deposit the amount of 25,998
My lords, kindly, my lords.
plus 75% of
That's 50%, my lord.
25,934 along with interest computed as of today, effective from 11/12/2008,
My lords, on the principal, 50%, my lords, kindly, my lord. Yes, we,
paying 75% with interest computed as of today, effective from 11/12/2008. Okay?
No.
Within how much time?
not 4 weeks' time.
Within 4 weeks.
Not 50% kindly, my lords. It's a substantial sum. I've already paid the entire amount. 2008, the money is given.
It's not going anywhere. The money is here. It's safe here. It will accrue interest in the FD also. Okay?
Please.
On such deposit, the amount shall be invested in an insured building SDL. Same order. See, rest we will be giving you dates.
It's grateful.
My lordship, I want to mention item 50. My lordship had given me a short date for today on the 29th of January. There's this urgency in the matter where an ex-employee of mine has taken my proprietary information and is roaming in the market and selling it to other people.
Which number, ma'am?
Item 50, sir, my lordship.
5015.
50, my lordship. Prime Trees Technologies Private Limited versus Swatantra Verma. So my lordship had given me a short date on the 29th. The next trial, the date before the trial court is on the 14th. So I'm requesting for a short date. And if it could be listed high on the board, my lordship.
Pardon?
If it could be listed high on the board, I am suffering.
That we will not say. 14th is the date there before the court below.
Yes, my lordship.
You can take an adjournment there.
Yes, my lordship, I will.
Who is the other side?
My
But the court below is not giving adjournments easily. Pardon? The court below is not giving adjournments easily. What are the proceedings there now?
They filed the applications now for production of additional document for interrogation.
We'll just take a chance, we can have it tomorrow, let us see. We'll have it tomorrow, ma'am, then we'll see.
oblige, my lordship. I'll mention it.
My lords,
kindly.
I make a motion in respect of serial number 51.
We'll give the
And-
dates, please.
My lord,
Lords,
serial number
serial
31
number
and 32, my
30.
lords.
Number 51 was fixed
31.
for today in view of an urgency, my lords, that the construction has been stopped on the property pursuant to an order under section 9 at the behest of a contractor who is not the owner of the property.
Which number you are saying?
Serial number 51, my lords.
Yeah, 51, who is the other side?
My lords, they have not entered appearance, my lords, they have neither filed the caveat. It is listed for the first time today. My lords, it's listed for the first time today. There is an urgent relief of stay that I am requesting. My lords.
First week of March.
My lords, serial number 31 and 32, my-
Serial number 64.
Pardon?
Serial number 64.
We'll come back, we'll come back. Hear us.
Yes, my lord. Yes, my
We'll
lords.
issue notice, you serve the other side.
Yes, my lords. May I request on the 4th of March, my lords, if it is not
Yeah,
inconvenient?
issue section 5. What is the stage there before the court below?
My lords, the petition under section 9 has already been allowed. Therefore, I am before the court, my lords.
Very well. Have you invoked the arbitration?
My lords, they have invoked the arbitration. I had cancelled the construction contract. My lords, he quantified the damages. After quantification, he has prevented me from putting up construction.
But any arbitrator appointed?
No, my lords, no arbitrator is appointed, my lords. I am informed they have filed a CMP. The CMP is pending, my lords.
CMP, what is the date there?
There is no date, my lords, given in the CMP, my lords.
Just say issue notice, give to for the March.
My lords, grateful, my lords.
Huh? See, we'll give you dates. What is the urgency?
7 to 11D saying no cause of action, and the amendments made in the written statement is the basis on which the trial court comes to a
What is
conclusion.
the urgency?
It's a suit of 21.
That's all. That's the urgency. Just give a date, ma'am, everything, and just see.
Request in March, my lords.
It's not possible. See, the position would remain the same. Let's have a purposeful hearing, you know. Getting the point. We want to hear it, but it's very difficult. So let's have a purposeful day. That's the reason we will give you.
My lord, may I make one submission?
Serial number 35, my lord, your lordship had reserved the matter. One,
We have
Yeah.
expressed ourselves.
yes, no,
Ah.
not that, my lord. Your lordship had posed a question as to when we have received the copy. We have received on 19/9/2017. That was what we wanted to bring to your,
Where do you say so?
it is in the copy application, my lord. I have not stated in the affidavit, but in the copy application, page 32 of the judgment.
We have asked you, I recollect having asked you the
Yes.
same. The reply was, it was not stated anywhere.
No, probably, my lord, she has, yes. I understand, my lord. That is why I wanted to just clarify.
Even till today, we are asking as if the date we have not mentioned that that's the impression we got, that's the submission, that's the impression we got.
Yes, my lord, we are
And
sorry.
that's the basic important point.
Yes, 99 we received.
My lords, serial number 31 and 32, my lords. My lords, 31 and 32, my lords.
What about their matter? Who is appearing? Who is the other side, Mr. Chadda? You are there. When can we have it, your matter? We'll give you a date, convenient date. We will hear you on that maintainability.
Lord, 31 and 32, my.
He will give you dates, okay?
That case you are taken up the other time.
Wait.
Madam.
73.
Madam, serial number 73, madam.
Court officer, madam, serial number 71.
One by one.
ಸರ್ ಆನ್ಲೈನ್ ಅಲ್ಲಿ ಇರೋರು ಹೇಳ್ಬಿಡಿ ಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್
My lord, 52.
Serial number 53.
52. 52, madam.
31, 32, serial.
ಅದು ಅಡ್ಜರ್ನ್ ಆಗಿದೆ ಸರ್
Serial
52.
number 53, madam.
ಹಲೋ
Hello, madam.
Serial number ಪಕ್ಕರ ಹೋಗಿ ನಮ್ಗೆ ಇಲ್ಲಿ ಮಧ್ಯದಲ್ಲಿ ಕಾಯ್ಕೊಂಡಿರೋ.
ಹಾ 52 ಏನಾಯ್ತು ನೋಡಿ ನೆಕ್ಸ್ಟ್ ವೀಕ್.
ಅವರು ಕಾಯ್ತಾರೆ.
ಸರ್ ಆನ್ಲೈನ್ ಅಲ್ಲಿ ಇರೋರು ಆಮೇಲೆ ಡೇಟ್ಸ್ ಕಲೆಕ್ಟ್ ಮಾಡ್ಕೊಳ್ತೀರಾ ಸರ್ ಲೈವ್ ಇದೆ
ವಿಲಾಸ ಐಟಮ್ 65
ಹಾ ಹೇಳಿ ಸರ್
One by one ಹೋಗಿ ಮೇಡಮ್.
ಅದಕ್ಕೊಂದು ಡೇಟ್ ಬರೀತೀರಾ ಅಮ್ಮ?
ಸರ್ ಒಂದ್ ನಿಮಿಷ ಸರ್ 65 ಹಿಯರಿಂಗ್ ನಲ್ಲಿ ಇದೆಯಲ್ಲ ಸರ್
Madam, 71 ಒಂದು.
ಸರ್ ಒಂದ್ ನಿಮಿಷ 65 ಹಿಯರಿಂಗ್ ನಲ್ಲಿ ಇದೆಯಲ್ಲ ಸರ್
ಅಲ್ಲಮ್ಮ ಅದು ಫಸ್ಟ್ ಟೈಮೇ ಬಂದಿರೋದು ಅದು ಆಫ್ಟರ್ ನೋಟಿಸ್.
ಹಾ ಹೌದು ಸರ್
ಒಂದು ಡೇಟ್ ಬರೀರಮ್ಮ. ಲಾಸ್ಟ್ ಟೈಮ್ ತಾವೇ ಡೇಟ್ ಬರ್ದಿದ್ದಕ್ಕೆ ಇವತ್ತು ಬಂದಿತ್ತು ಅದು ಮತ್ತೆ ಹೀಗೆ.
ಸರ್ ಹೇಳಿ 21/4
ಹಾ 52 ಮೇಡಮ್. 52.
ನೆಕ್ಸ್ಟ್ ಹೇಳಿ ಮೇಡಮ್
52 and date ಕೊಡಿ ಮೇಡಮ್.
ಸರ್ ಒಂದ್ ನಿಮಿಷ ಆನ್ಲೈನ್ ಅಲ್ಲಿ ಇರೋರು
52.
50
52 52.
ಸರ್ ಬೇಗ ಹೇಳ್ಬೇಕು
53.
ಒಂದು ಡೇಟ್ ಕೊಡಿ 52ಗೆ. ನಾಟ್ 52. 50 ಅಲ್ಲ 3 ಅಲ್ಲ 52 ಏನ್ ಕೊಡ್ತಾ ಇದ್ದೀರಾ? 52.
52 ಸರ್
ಹಾ ಹಾ ಹಾ
ಸರ್ 52
ಹಾ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಒಂದು ಡೇಟ್ ಕೊಡಿ
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಇಲ್ಲ ಸರ್
ರೆಸ್ಪಾಂಡೆಂಟ್ ಗೆ.
15/4
ಓ ಮೈ ಗಾಡ್.
Madam, 53 ಹೇಳಿ.
53
ಹಾ
53 no ಅಷ್ಟೇ ಮೇಡಮ್ 16/4
16, okay, thank you.
31 and 32 ಯಾವ ಡೇಟ್ ಹೋಗಿದೆ ಮೇಡಮ್?
ಆನ್ಲೈನ್ ಅಲ್ಲಿ ಯಾರಿದ್ದೀರಾ?
31 and 32 ಮೇಡಮ್ ಯಾವ ಡೇಟ್ ಹೋಗಿದೆ?
31 32 ಅರ್ಜನ್ ಆಗೋಗಿದೆ ಸರ್.
ಬೆಳಗ್ಗೆ ರೈಟ್
ಮೇಡಮ್ 61 ಒಂದು ಡೇಟ್ ಕೊಡಿ ಮೇಡಮ್.
61 ಸರ್ 24/4
ಮೇಡಮ್.
ಆಕ್ಚುಲಿ ಮೂವ್ ಮಾಡಿರೋದು ಬಂದಿದೆ. ಮತ್ತೆ ಅರ್ಲಿ ಹಿಯರಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ಎಲ್ಲ ಆಗಿರೋ ಕೇಸ್ ಅದು.
ಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ ಸರ್
71 ಮೇಡಮ್.
71
ಹೌದಾ, ಸ್ವಲ್ಪ ಬೇಗ, ಯಾಕಂದ್ರೆ ಅರ್ಲಿ ಹಿಯರಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ಎಲ್ಲವಾಗಿದೆ ಅದು. ಪ್ಲಸ್ ಇವನ್ ಅದು ಮೂವ್ ಮಾಡಿ ಬಂದಿರೋದು ಇವತ್ತು.
ಸರ್ ಮಾರ್ಚ್ 25.
ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು.
ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 70 ಯಾವ ಡೇಟ್ ಆಗ್ಬೋದು?
ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 73 ಮೇಡಮ್.
ಏನ್ ಹೇಳಿದ್ರೆ
ಇರಿ ಸರ್, ಅವ್ರದ್ದೆಲ್ಲ ಆಗೋಗ್ಬಿಡ್ಲಿ ಇರಿ ಸರ್, ಆನ್ಲೈನ್ ಅಲ್ಲಿ ಇದ್ದಾರೆ ಅವ್ರದ್ದೆಲ್ಲ